So, dear participants, I think that we could start the second panel. So please keep quiet. Thank you very much for your patience. And now I would like to start to present actually the title of the first panel. So the first panel is entitled Judicial Reforms in Poland and Ukraine, Supreme Courts, Procedures and Judicial Councils. And this panel will be chaired by PhD student from Jagiellonian University, from Doctoral School in Social Sciences, Paulina Jablonska. So I will give the floor to Paulina, please.
Thank you for inviting me. It's a great pleasure to be here. We have 3 presentations in this panel in our schedule, and then we will move to the discussion. So let's start with the first presentation by Maciej Zygmunt Daryna Krynhak, sorry for my pronunciation, Tit Andreev and Maciej Chop. The paper is titled How to Reform Supreme Courts in Poland and Ukraine. You have 30 minutes, so please keep the time limit to spare enough time to our discussion. The floor is.
Thank you very much. Today I'm going to focus on a topic of relatively small but important part of Polish Supreme Court functioning, extraordinary appeal. The Act on the Supreme Court, adopted in December 2017, introduced a new additional extraordinary remedy, which was intended to serve the correction of court decisions that are incompatible with the constitutional principle of social justice. I must say that during the first few years of the functioning of this institution, it was the subject of interest in the legal doctrine relatively often. Much has been written about whether the legislator correctly resolved the natural tension between the principle of justice and the durability of judgments. A lot of space was also devoted to the practical aspects of its functioning, in particular, how to shape the basis for an appeal. However, I would like to leave these issues outside the mainstream of my speech. I would like to try to answer the question whether the extraordinary appeal contributed to shaping knowledge about the constitutional rights of individuals, and to what extent the solutions of the Act on the Supreme Court actually lead to educating on the constitutionality of the judicial process of applying the law. As an introduction, however, it should be noted that the extraordinary appeal was to be the missing link in the human rights protection system in Poland. It was also supposed to be a slightly late reaction of the legislator to the signaling decision of the Constitutional Tribunal of March 2003, which pointed out the lack of an extraordinary remedy ensuring effective protection of constitutional rights violated in the course of judicial application of the law. This assumption seems to be correct in the terms of direction. In my opinion, the abstract general method of regulation establishing a conditional relationship of priority is not fully adequate to resolving conflicts of constitutional rights and freedoms. The circumstances of particular cases may determine a different legal and constitutional assessment compared to a model case that does not contain the indicated circumstances. In this respect, all types of judicial discretion, examples of application or refusal to apply the exception clauses, special situations or mechanisms of adequacy should be subjected to special constitutional control. In my opinion, this is primarily about situations in which the courts, while educating prima facie in accordance with the law, in fact, make evaluation errors resulting from the defective omission in the considerations of the issue of the conflict of constitutional principles occurring in concreto in the context of a specific court proceeding. Such a belief seems to me correspond well with the specific basis for the extraordinary appeal regarding the violation by a court decision principles of freedoms and rights of humans specified in the Constitution, as well as the division of functions between the Constitutional Tribunal and the Supreme Court, which is clear, at least at first glance. However, can this hypothesis really be defended in the light of observations of judicial practice? My research of a randomly selected group of Supreme Court judgments in the parts describing the allegations in the appeal, built on the basis I've already mentioned, seems to falsify the presented assumptions. The group of entities authorized to file an extraordinary appeal is limited to a narrow group of public law entities, I'd say public interest advocates. Despite the professional nature of the complaining entities, there may be far-reaching doubts about the way in which the extraordinary appeals have been formulated based on the so-called constitutional basis, especially in comparison to the basis of a gross violation of the law or even an obvious contradiction of factual findings with the evidence. The latter two are, in most cases, better justified in a methodologically correct way, which unfortunately cannot be said about the so-called constitutional basis. In the vast majority of the analyzed extraordinary appeals, the allegations against judgments based on the violation of individual constitutional rights seem to result, in fact, from the violation of sub-constitutional provisions. The complainants identify the content of constitutional regulations with statutory acts in such cases where there is just a correlation in content between these regulations. To illustrate this problem, I will now cite a few examples. In one of the cases, the Prosecutor General saw the cause of breach of constitutional rights to a fair and just hearing of a case by a court in, quote, unreliable and therefore violating the principles of procedural justice assessment of existing evidence in the case. In another case, the financial ombudsman alleged that the court of second instance violated the constitutional principles as a result of failure to apply a statutory act in accordance with the understanding of a given legal institution commonly accepted by the courts, which resulted in violation of the principle of citizens' trust in the state and the law, as well as the state's loyalty to citizens who, based on the guarantees arising from the principal democratic state of law, have the right to expect that the provisions of law and the manner of their interpretation will be predictable and understandable to their addresses from the point of view of the constitutional principle of loyalty and equality. Similarly, in another case, the Prosecutor General alleged a violation of the principle of trust in the state, the principle of legal security, and the principle of the rule of law in issuing a judgment violating the mandatory provision of Act on Municipal Self-Government. The cited examples, which unfortunately can be multiplied, clearly show that the introduction of an extraordinary appeal has not led to a satisfactory state of awareness of public interests advocates regarding the application of constitutional law in practice. Often, constitutional regulations are treated instrumentally, in fact, devoid of independent normative content, and constitute a pseudo-axiological basis for allegations of violation of the law in the strict sense. But was this really the Constitutional Tribunal intention when formulating the signalism decision I mentioned at the beginning? I will leave you with this question. Thank you very much.
Now I will present our topic about how to reform Supreme Court in Ukraine. With the declaration of Ukrainian independence in 1991, the process of democratization and reform of the judicial system began. One of key tasks was the creation of an independent, impartial Supreme Court, as well as the introduction of concept of legal and judicial reform in Ukraine in 1992. The concept states that the courts were overloaded with cases and declares that they should be independent from the executive and legislative branches of government. After the Revolution of Dignity in 2014, judicial reform became one of the main priorities of new government. In 2016, amendment to the Constitution of Ukraine and a new law on the judiciary and the status of judges were adopted, which initiated a large-scale transformation of judicial system. One of key elements of the reform was the creation of new Supreme Court, which replaced the previous two, the High Specialized Court for Civil and Criminal Cases and the High Administrative Court. The new Supreme Court was formed according to principle of competitive selection, which aimed to ensure its impartiality and professionalism. In 2016, a large-scale process of reform in the judicial system began in Ukraine, one of key stages of which was the creation of new Supreme Court. This process was intended to create impartial and professional courts that would meet the highest standards of the rule of law. To achieve this goal, an updated competition for the selection of 150 judges for new Supreme Court was held. So, the reform of judiciary in 2016. The reform began with drastic structural changes. The existing Supreme Court, as well as the high specialized courts for civil and criminal cases and high administrative court, were dissolved. This dismantling was aimed at eliminating potential redundancies and optimizing the higher echelons of the judicial system. It was a symbolic gesture of severing ties with a system perceived as untrustworthy. From the ashes of the old system arose a completely new Supreme Court. This new beginning was meant to distance itself from past controversies. The reform simplified the court structure, creating a three-tiered system with the Supreme Court at the top. This streamlined structure was intended to increase the efficiency and clarity of judiciary hierarchy. The cornerstone of the reform was ensuring the independence of newly created Supreme Court. This was achieved through a transparent and competitive process for the selection of judges. The process involved public control and participation of international experts. This strict selection was intended to attract highly qualified and impartial judges free from outside influence. The reform also introduced specialization in Supreme Court. Chambers dedicated to specific branches of law such as civil, criminal, and administrative law were created. This specialization was intended to ensure that judges have in-depth knowledge of the legal issues they are dealing with. By focusing on specific areas, judges could gain a deeper understanding of complex legal issues. 8 years later, was the reform successful? Institutional structure for judicial reform. Also, the 2016 reform was a significant step toward. It was not without flaws. Some of key issues that have arisen are, firstly, opaqueness and bias of the competition. Some stages of the competition were not transparent, which raised doubt about impartiality of the selection of judges. There were also fears that political interests could influence the outcome of the competition. The initiators of the reform paid great attention to the personal issue in order to overcome corruption among judges and increase the public trust in the representatives of this profession. Judges were deprived of full immunity, which stood in the way of bringing them to justice for violation of the law and the principle of fair justice. For the first time in the history of Ukraine, lawyers and scientists were able to apply for the position of judges. Each judge had to undergo qualification assessment procedures. This applied both to new candidates for position in the courts and to those judges who had already worked in the judicial system before the reform. For this purpose, a special body was created, the Higher Qualification Commission of Judges. It includes judges, lawyers, and scientists. To involve the public in the process of election judges, the Public Integrity Council was formed. Its purpose is to assist the Higher Qualification Commission of Judges in determining the compliance of candidates for the position of judges with the criteria of professional ethics and integrity. The Commission examined candidates according to several parameters: professional competence, integrity, professional ethics, psychological stability. To avoid base marks, each candidate is assigned a unique code during the writing exam, and the examiners do not know whose work they are taking. Oral interviews with candidates are broadcast live. The large-scale evaluation caused mixed reaction from the judge. About 2,000 of them resigned from the judicial system even before the evaluation procedure began. There is a problem of staff shortage, which the Higher Qualification Commission's plans to solve during the next wave of evaluations. In addition to courts of first instance, the Commission select candidates for the Supreme Court and the High Anti-Corruption Court. Secondly, insufficient qualification of some judges. Some of the winners of the competition did not have sufficient experience as judges or work experience in specialization to which they were assigned. Thirdly, problems with integrity. Some judicial candidates had dubious reputation or were involved in corruption schemes. Fourthly, inefficiency of the work of court. Due to the deficiencies in the qualification and experience of judges, as well as due to bureaucratic procedures, the work of the new Supreme Court was not as effective as expected. Indeed, these shortcomings led to consequences. The public does not trust the new Supreme Court because of doubt about its impartiality and competence. Inefficient work of the Supreme Court leads to delays in the consideration of cases and undermines access to justice. Deficiencies in the work of Supreme Court can negatively affect the establishment of the rule of law in Ukraine. Therefore, in order to overcome these problems and ensure the success of the reform of Supreme Court, it is necessary to take the following measures. First, it is necessary to ensure the transparency and impartiality of the competition. The process of selecting judges should be as transparent and impartial as possible to ensure that only the best candidates get to the Supreme Court. Secondly, increasing the qualification requirement for judges. It is necessary to establish clear and strict qualification requirements for judges to ensure that they have the necessary experience and knowledge to perform their duties. Thirdly, application of strict measures against unscrupulous judges. It is necessary to introduce strict measures against judges who violate ethical norms or commit illegal acts. Fourthly, it is necessary to optimize bureaucratic procedure, introduce modern technology, and improve the administrative management of the court to increase its efficiency. And fifthly, civil society and other stakeholders should be actively involved in the process of reforming the Supreme Court to ensure that it meets the needs and expectations of society. And disciplinary procedures for judges of the Supreme Court of Ukraine 2019. In 2019, updated disciplinary procedures for judges were introduced in Ukraine, which included judges of Supreme Court. The purpose of these reforms was to strengthen the responsibility of Supreme Court judges for illegal action and prevent corruption in the judicial system. Regarding changes to legislation, the law of Ukraine and Supreme Council of Judges clearly defines the grounds for disciplinary responsibility of Supreme Court judges, as well as the procedure for conducting disciplinary investigation and applying disciplinary sanction. The Code of Judicial Ethics of Ukraine established ethical principle and norm of conduct for Supreme Court judges. There are some disadvantages. First of all, insufficient independence of the High Council of Justice. The High Council of Judges, which is responsible for investigation and punishing Supreme Court judges, may still be subject to political influence. This can result in judges not being prosecuted for wrongdoing if they have political support. Lack of transparency. The process of investigation and punishing Supreme Court judges is not always transparent. This can lead to a lack of public confidence in the outcome of disciplinary procedures. Inefficiency. Disciplinary procedures can be too slow and ineffective. This may result in the judges who have committed offenses not being punished in a timely manner. And insufficient severity. Sanctions that can be applied to Supreme Court judges for misconduct may not be severe enough. This can lead to judges not taking disciplinary procedure seriously. So my part is so. Tit will be continued.
Yes, thank you very much. Dear moderator, how much time do I have? And do you hear me well?
Yeah, we hear you, and I think that 10 minutes.
10 minutes. So I could share my thoughts on judicial reforms with your honored academic community too. So our topic is worded like how to reform the Supreme Courts. But I would adjust this question, how to reform the Supreme Court effectively. Because as we could see, the last 30 years, Ukraine does reform its Supreme Court or its judicial system, and we clearly indicated the problems of our judicial system in 1992 when the first strategy was adopted, but 30 years later we could state that we haven't resolved these problems yet, and even if the reform of the Supreme Court, which took place in 2016, was quite successful in comparison with other parts of the judicial system, it is not still good enough, and there are ways how to improve it. So what are the factors which influence the successfulness of the judicial reform? In my view, there should be an overlapping consensus between the international community and the national society. Then, the second level, there should be a consensus among the politically elected bodies. And the third, there should be a consensus among the judges and the staff of the judiciary themselves in the need of the judicial reform. And we should establish some aims and some indicators which would allow us to evaluate the effectiveness of the judicial reform. If we are talking about the improving the judicial performance, we could divide these steps which could help us to build a better judicial system in three parts. The first part is improving the selection process and the appointment of judges. This appointment should be independent, politically independent, and it means that political actors in Ukraine should understand that achieving short goals, for instance, appointing a politically influenced judge, could help you in short-term perspective, but then this judge could judge yourself, and he could change his mind according to new political wills, and thus enabling some politically influenced decisions, which is very bad in our society, and which means that the legal norms are applied without the necessary understanding of consequences of your decisions. So if you act legally, the judge could take an illegal decision, and thus your rights would be violated. So this process should be as transparent as possible. And here we have some problems in Ukraine, as the appointing bodies do not take appropriate measures in regard to the decisions of the Public Integrity Council. They are often ignored by the political bodies and by judges themselves. I could mention one example. The current head of the Supreme Court of Ukraine, Stanislav Kravchenko, in 2017 had a disqualification or bad opinion from the Public Integrity Council. They found him not satisfying the criteria which are necessary to hold in a position of a judge. And recently, when the former head of the Supreme Court was arrested and now he is under investigation for corruption, the judges themselves elected a new head who is not, who does not correspond to the integrity standards, and who could be unfair too. Here we should take in mind that there are different standards of proof when we are talking about judges. Some members or some politically appointed bodies think that there should be the standard beyond reasonable doubt. So if the judge is appointing, so we should consider himself, and some civic activists or other bodies should prove beyond reasonable doubt that this judge is fair. For me, or unfair. For me, the ground reasonable doubt is enough. So if you believe that this judge is unfair or this judge had some corruptional history, it is enough to disqualify this judge and not to elect him. If you're talking about the second stage, it's the tenure of the judge. There are some ways how to improve it, and I think that the current Supreme Court could be the first court in the world which could use AI tools in its work. For instance, it's a big problem of our Supreme Court that it is overloaded with cases and applications. So AI tools could be used just for analyzing big amounts of text, analyzing applications, and then the judge or the court staff would take decisions based on these materials which are provided by AI. So we have two steps. two-step procedures when firstly AI do some work, and then a person, a human, a court staff or a judge just check the decision and could use the already made decision, or could improve it, or just change if AI tools does not allow to achieve the results which we see as justifiable. And the third step in this, or the third stage in this process is the procedures which are connected with the situations when the judge is suspected in committing some disciplinary omissions or committing corruption cases. So in this case, disciplinary proceedings should be more effective, and the bodies which are responsible for evaluation of their behavior should be more independent and should be more efficient in this way. So in this regard, these disciplinary proceedings should be as much transparent as possible. So the public should have access to all materials. The public hearing should take place, and we have some cases with the selection of constitutional court judges. So these cases should be translated online, so or broadcasted online, so that the public in Ukraine could see these situations and could evaluate themselves is these procedures are effective or not. And political bodies should not intervene in this process. So there should be a political culture among politically appointed bodies and other governmental officials that they should not interfere in this process. And for achieving long-term goals of establishing effective and independent judiciary in Ukraine, they should just wait for the just decision. And last but not least, what can we do as citizens in order to improve the transparency and effectiveness of the judiciary, especially in the context of European integration? As I see, as responsible citizens, we should take care of the political party programs and public declarations of politicians. For me, judicial reform is a reform number one in Ukraine. All other problems are derived from this problem. And in this regard, we should demand from political parties to include the measures which are aimed to improve the judiciary in Ukraine in their political programs, as well as create some demand, public demand, for the just judiciary in Ukraine. Thank you very much, and I'm waiting to your questions at the end of our panel.
Thank you very much. Now there's a time to turn to the second presentation, which is entitled How to improve the judicial procedures in Poland and Ukraine. And our speakers will be Zuzanna Topyło, Olena Mokulenko, Angelina Szaman, and Eva Overczak.
To answer this question, firstly, we need to talk about the quality of judicial proceedings. So this question of judicial proceeding is a crucial one, especially in the context of rule of law, because the high quality judicial proceeding is the framework for it, which guarantees that people and legal entities have the right to a fair trial. In a similar way, it is a significant precondition for an economic development of a country, facilitating the creation of appropriate investment climate and encourages exactly business activity. Oh yeah. So the general provisions of court proceedings are like a set or a system of procedural actions aimed at fulfilling the main tasks of criminal proceedings. It should be noted that on 17 November 2014, the panel of the High Specialized Court of Ukraine decided to provide the court with the following clarification. In administrative justice, the court should take into account the fact that in accordance with the Article 6, paragraph 1, a reasonable time limit in criminal proceedings aims to ensure that the accused doesn't remain for too long under the burden of accusation. The validity of must be proved. However, in Ukraine, courts often fail to comply with the time limits for consideration of cases, which in turn leads to prolongation of trials and violation of the rights of the parties,
specifically with regard to the quality of the trial. This is due to the following. Yeah, so firstly, there is a significant overload of courts due to the lack of judges. One of the reasons for this may be the process of appointing judges, namely their competition for the position of judge. Due to the absence of public form of voting, members of the High Council of Justice may be influenced by political parties or, for example, interest groups. Of course, the Judicial Selection Commission is not obliged to publish their reasons for its decisions on the appointment of judges, but since the decisions are often unreasonable, this may lead to the public distrust. Yes, so it means like to determine the credibility of court, which may result in this decision being challenged in court, which will turn cause additional time and resources to be spent. Yeah, and all of this led to the fact that, according to statistics, the High Council of Justice decided to dismiss 388 judges in 2023-2024. 349 resigned, 26 voluntarily, and 1 for the health reasons. The resigned judges have experience like 16, 18 years of judicial experience. The most experienced and qualified judges resigned due to the excessive workload. At the same time, since the high qualification commissions of judges of Ukraine began its work, the High Council of Judges has decided to submit a proposal to the President of Ukraine to appoint 27 judges to local courts, 3 judges to commercial courts, and 3 judges to administrative courts. This means that the number of dismissed and appointed judges is significantly different and cannot be compared. Yes, secondly, the complexity of the case may also have an impact on the non-compliance with Article 6, Paragraph 1 of the Convention on Protection of Human Rights and Fundamental Freedoms. This convention also refers for the circumstances of a complex case, such as prosecution, a number of persons involved in the proceedings, such as accused and witnesses, or international dimension of the trial. Particularly complex cases are also mentioned, which are characterized by large-scale fraud involving numerous commercial organizations or complex transactions to evade the control of investigate authorities, requiring the complex accounting and financial examinations. And it should be emphasized, however, that even if the case is truly complex, the court cannot find unreasonable long periods of stagnation reasonable, nor it can be sufficient to justify the entire duration of the proceedings. One of the main points is also the court apparatus. In accordance with the law of Ukraine on judiciary and status of judges, it provides organizational support for the work of the court. It is also guided by the Constitution of Ukraine, the laws of Ukraine, like on civil service, on prevention of corruption, the labor code of Ukraine, and other codes and laws of Ukraine. So the lack of judges in it is directly the main quest. And as mentioned earlier, this is due to the procedure of appointing judges, the excessive workload of judges, and the complexity of the cases then take a long time to consider. However, one of the catalysts for dismissing a large number of judges is also their salaries. After all, having analyzed the average salary and incentive payments for May 2024 of the staff of the Economic Court of Odessa Oblast, where the average salary of the management, yes, like head of the body, secretariat staff, and their deputies for the reporting months, May 2024, is 67,181.12 hryvnias. And the average salary of the patronage service employees, including judicial assistants and workers, is 25,432.94 hryvnias. So that is the difference.
Dollars.
Hryvnias.
Dollars. $200. Okay.
So that is the difference is 37.86%. This is why many ambitious employees decided to resign. So low wages also lead to increased corruption. And one of the most famous examples in Ukraine is Vyacheslav Knyazov. So he is, for now, he's the highest ranking judge in the history of Ukraine who was detained for corruption. Online justice is also one of the most important issues today. It is important to know that the new challenges such as war and experience of COVID-19 are the basis for the digitalization of justice. That is why the Council of Judges of Ukraine has adopted recommendations of the work of courts during martial law, namely to determine the specifics of courts' work based on the current situation in the region, to appoint a person reasonable for the accounting of employees, and to transfer all employees to remote work, to focus on urgent trials, and to continue to consider issues related to the return of various procedural documents, at least until the end of martial law, and to allow the use of any technical means, including personal ones, during the trial. These recommendations include peculiarities of the work of the court on the front line, peculiarities of court proceedings during martial law and online justice, which have become challenges for the administration of justice in Ukraine. And it should be also noted that in Ukraine, parties to a case who are located in the temporarily occupied territory or whose last known address of residence of location is in a temporarily occupied territory and who don't have an electronic cabinet are notified of the adoption of the relevant court decision by posting information on the official web portal of the Judiciary of Ukraine with a link to the web address of such court decision in the Unified State Register of Court Decisions, or by posting the text of the relevant court decision in that web portal. So, thus, the Ukrainian judiciary is faced with a number of interrelated problems, and their solution must also be comprehensive. In order to improve the duration of court proceedings, it means to meet the reasonable time limit, it's necessary first to increase the number of judges, to relieve them of the excessive workload that in turn leads to delays. To do this, the process of appointing judges should be first changed somewhat, namely by making it more public and allowing the public to express its opinion on candidates or collecting feedback on candidates from other stakeholders such as lawyers or advocates. Second, it requires raising the salaries of the court staff and making them more or less equal for all. This may help to encourage ambitious lawyers to work in the courts. And judges could also be a right of reviewing insignificant cases by transferring them to some other bodies, such as, for example, administrative commissions. Yes, so they would review cases of violations of tax or antitrust of labor laws, or, for example, arbitration courts. Which will review commercial disputes between legal entities and individual entrepreneurs. So in terms of digitalization of judiciary, Ukraine is more advanced in the regards than a country, for example, like Poland, and it's constantly improving it, becoming an example for some European countries. And disciplinary proceedings is also an integral part of the quality of judicial proceedings. So my colleague Lena is going to talk about this question right now.
Yes, so the disciplinary offenses with the aid of using judges or just with judges inflict damage to society as they distort the concept of the character of justice, lessen its social value, harm the hobbies and individuals in a trial, which commonly impacts the authority of the court. The nature of disciplinary court cases calls for theoretical evaluation and improvement of criminal law regarding composition and competence of the body answerable for its implementation. It's an important part that which can support an existence of the rule of law in our country for today. And so here in this part, we're going to talk about which issues and cases we have to this question,
how now such proceedings go and awareness of improvement from our point of view. First of all, we want to talk about problems that lead to disciplinary court proceedings. As the main, we can name abuse of judicial authority, corruption or bribery, violation of judicial ethics, failure to comply with legal standards, improper handling of cases, and conflicts of interest. If go deeper in some of them, it has a lot of aspects. For example, under unprofessional behavior goes actions which might be unbecoming of a judge, consisting of the usage of beside the point language, being impolite or dismissive in the direction of courtroom docket participants, or failing to hold the decorum within inside the courtroom. So judicial field is one of the sorts of special statutory field, as it miles associated with the expert interest of judicial authorities. Judicial field is, in a slender experience, is social policies of conduct of justice, necessities which are recommended to them, and their real implementation. Disciplinary obligation of judges as a kind of felony obligation is composed in enforcing adverse deprivations of a moral, fabric, and organizational nature at the violator of judicial area, and is one of the manner of making sure the conformity of the hobby and conduct of judges. Disciplinary court cases are initiated upon a criticism concerning a decides disciplinary misconduct, disciplinary criticism submitted according with the law of Ukraine on the judicial system and the status of judges, or upon the initiative of the disciplinary chamber or the high qualification commission of judges of Ukraine in instances particular via way of means of law. It's chapter 1 of article 42 of the law of Ukraine on the Supreme Council of Justice. And this disciplinary includes undertaking an initial take a look at and verification of a disciplinary criticism beginning a disciplinary case, and then thinking about a disciplinary criticism and decide on bringing and refusing to deliver a decide to disciplinary responsibility. Consideration of a disciplinary case takes origin in a place assembly of the disciplinary chamber, wherein the judge, the complainant, and their representatives participate. The judge has the right to appeal the decision of the disciplinary chamber to the council no later than 30 days from the day of its adoption, as well as with the permission of the disciplinary chamber, the complainant. According to Article 6 of Convention of the Protection of Human Rights and Fundamental Freedoms, everyone has the right to a fair and public trial within a reasonable time by an independent and impartial court established by law. As my colleague said, now it goes like a process of digitalization due to war and so on, to do like easier the process of disciplinary proceedings and to improve it. So Ukraine has introduced electronic case management systems that allow for the digital handling of disciplinary cases against judges. This includes the submission, processing, and storage of case documents electronically, the use of video conferencing tools for conducting disciplinary hearings, and this has become particularly relevant during the COVID-19 pandemic too. But still, we have a lot of problems, such as transparency, quality of our proceedings. But I want to stop on the biggest one, in my opinion, is the corruption. And that is like one of the biggest reasons of disciplinary proceedings of judges. The solution to this problem has been in development for quite some time, but since the last report of the European Commission, some work has been already done. New legislative policy and institutional improvements have been made, including the adoption of a national anti-corruption strategy, accompanied by a comprehensive state program for its implementation. Ukraine's judicial system requires major reforms to improve the efficiency, transparency, and independence of judges too. This includes reform of case administration management, provision of necessary resources for judicial institutions, as well as professional development and independence of judges. So disciplinary offenses committed by judges significantly harm society by distorting the concept of justice, reducing its social value, and undermining public confidence in the judiciary. Such actions can also negatively impact the interests of individuals involved in trials, ultimately affecting the authority and integrity of the court system. The disciplinary proceedings are crucial in maintaining the rule of law in Ukraine by ensuring that judges adhere to ethical standards and legal requirements. So it was an overview how to improve the judicial proceedings in Ukraine, and now our colleagues from Poland are going to tell you how to improve it in their country. Thank you.
Okay, so thank you very much. Good afternoon, everyone, one more time. My name is Ewa Overczuk, and me and my colleague from Poland, Zuzanna Topyło, will talk about how to improve judicial procedures in Poland. And I will start with a quick and brief introduction because personally, I believe that a successful national judicial system is a system that works like a living organism. And I mean, it is subject to change, and this change is driven by two factors: the need to adapt to reality, which is constantly changing, and the need to provide people with easy access to justice in the broadest sense. Whether a given judicial system is efficient and modern depends on a great many factors, such as legal, political, human, and financial. And our colleagues from Ukraine talked about what should be done to improve judicial procedures in Ukraine. And I think that as Poland, we are struggling with similar problems. And therefore, in our part of the presentation, we will undertake to characterize the causes inefficiencies in the Polish judicial system, and we will try to propose our solutions. The first part will address the issues of accessibility and informatization of the judicial procedures, and the second one will be focused on the specifics and remedial proposal for disciplinary proceedings. So to begin with, according to the data available on the website of the Ministry of Justice, the average duration efficiency of court proceedings of selected categories of first instance cases of district and regional courts, including the duration of mediation, totaled to 5.9 months in 2023, the same as in 2022. At the same time, it was 1.8 months longer than the average duration of court proceedings in 2011, and at the same time, 1.2 months shorter than the average duration of court proceedings in 2021, when this time was the longest at 7.1 months. Moreover, back in 2015, European Court of Human Rights in Rutkowski and others versus Poland case judgment, stated that the problem of protracted proceedings in Poland is systemic. On the other hand, during a survey conducted in June 2022 by the Center for Public Opinion Research, adult respondents that was asked to evaluate the performance of the judiciary in Poland gave 55 of negative opinions. And in the meantime, we have Article 45.1 of the Polish Constitution that states that everyone shall have the right to a fair and public hearing of his case without undue delay before a competent, impartial, and independent court. So where does the problem lie, and whether and how it can be solved? The protractedness of court proceeding is a situation that involves many factors, one of which is undoubtedly the way the justice system in Poland is organized. Although the number of field judicial positions increased in 2023 from 9,748 in 2022 to 9,895 in 2023, after a two-year downward trend, according to data provided by the Ministry of Justice, the percentage of cases handled by one judge is falling from 591.5 in 2022 to 578.4 in 2023. In, for example, year 2018, and still nowadays,
one could read information that there are about 1,000 cases per district court judge in Poland. Judges lack staff facilities. We are talking about both assistant and other personnel. Earnings of court employees do not encourage this kind of work. As the example of the Rzeszów and Warsaw appellate, it's the numbers of the appellate in Warsaw, the disproportion in salaries can even reach to 2,000 zł. And it was in 2014, and this kind of report wasn't done later, but as you can see, the disproportion is really high. In the 2024, the basic earnings of a judge assistant range from 5,000 to 8,000 zlotys, and trade unions draw attention to the way salaries of court employees are shaped in Poland. Salaries are shaped by ordinance of Minister of Justice, which are based on indicating a lower salary limit, leading to a situation in which most employees receive salary shaped just around or at that level of the lower salary limit. In 2023, court and prosecutorial service employees organized a protest against low wages, and according to media reports, in 2023, among over 8,000 prosecutorial service employees, almost 1,300 employees received minimum wage, and it was 3,490 zlotys before taxes. And like you've heard from our colleagues in Ukraine, the earnings of personnel working in Ukraine courts were about, when it comes to złotych, 6,700. So as you can see, there's a different story here in Poland. It is also pointed out that the way in which cases are managed also negatively affects the number and timing of cases recognized by a given judge. Currently in Poland, each serving judge is assigned referrals. In example, set of cases that he or she is assigned to hear. A referral includes all the cases in which a given judge has been assigned and which he or she is tasked with deciding. Therefore, it is not difficult to imagine that these cases can number in hundreds. So judges do not plan their work for individual cases, but for the entire referral. And as a result, hearings are not conducted in a concentrated manner, day by day, although this is allowed and even advisable, for example, in the Code of Civil Procedure. This in turn significantly prolongs the processing of a case. How can the issues I have outlined be influenced? There are several solutions in my opinion. First of all, an urgent change is needed in the amount and the disparity of salaries of court employees. Standardizing salaries and increasing them will allow the courts to deal with the problem of staff shortages, and supporting judges by hiring assistants can also have a positive impact on the time it takes to process case, and therefore on the quality of the entire system. Another important step would be to change the approach to case management, to move from the level of the referrals to the level of case types. And here the field opens for another discussion on the specialization of judges, which is also still going on in Poland, and which deserves at least a separate speech. And lastly, increasing the use of technology and electronic communication tools in court proceeding would also contribute to more efficient and faster proceedings. At this point, I will move on to the next point of my speech, which is precisely the issue of digitalization and informatization of the Polish judiciary. Already before the pandemic, I mean COVID-19 pandemic, there were voices in the expert community about the need to modernize specific areas of the justice system in the terms of data access and informatization. Already in years 2015 and 2017, court rulings were disseminated through the judgment portal, or the information portal was implemented as a system for collecting information on ongoing cases. It was accessible to parties and attorneys. Nevertheless, many elements of informatization were still not put into operation at that time, such as the launch of electronic delivery of letters. In 2020, the Ombudsman formulated demands for the improvement of court procedures, among which was the demand to among those was the demand to adapt the method of serving pleadings and other court documentation in criminal proceedings to the current level of technological and social development. It was 2020. And there was also the demand to urgently spread electronic service in civil proceedings. There was also the government's strategy for the modernization of the area of justice in Poland for years 2014 to 2020, authored by the Ministry of Justice, which assumed a very broad spectrum of projects aimed at increasing the accessibility and openness of the system. So has the COVID-19 pandemic, which erupted in late 2019, thwarted the government's plan for the digitalization of the judiciary? I would say not necessarily. After the outbreak of the pandemic, litigants experienced significant difficulties in accessing the courts, and at first the consistency of the message transmitted by courts was very chaotic and different for each court, and access to information was impossible. But despite this, it was possible to implement a system of hearings by means of remote communication and to set rules for the circulation of correspondence. An undoubted benefit for the judicial system is the permanent implementation of the remote hearing system, which, despite the end of the pandemic, the courts still use today. It was the COVID-19 pandemic that clearly demonstrated Poland's need for the implementation of a unified and comprehensive IT system that would allow the execution of all formalities. For example, from the establishment of cases to obtaining the justification of a ruling, as well as which would be a tool for comprehensive communication between the parties, the courts, and the attorneys, and a place to receive notices of procedural deadlines and automatically generated summaries. Some courts have succeeded in introducing such solution, but this is still not a common model, and Polish judiciary operates on the basis of a number of distributed systems, but these systems are not the one system. What can I say more? Because I see that we have a little time. But during the pandemic, the government created a bill to improve the consistency of the IT system, but it never came into the light. And I would say the pandemic has undoubtedly reviewed the discussion of the digitalization of the Polish judicial system. And this discussion should be taken into another level, but it is important that this process is carried out from the perspective of citizens and entrepreneurs, and not just professional attorneys, which means putting emphasis on good translation of the portal's functionalities and their intuitive operation. And another discussion about this system is discussion about using artificial intelligence tools, but this is something that I think that we are not ready yet in Poland. Thank you very much.
So good afternoon, everybody. I will talk about disciplinary proceedings. And disciplinary proceedings in Poland and in Ukraine are crucial to enhance the rule of law. However, the impartiality, stability, and social trust require a delicate balance. Therefore, the nature of disciplinary proceedings demands methodological, psychological, social, and procedural changes. I will focus on the formal aspect of judges' disciplinary responsibility, outlining the background of the problem, its current shape, and proposing improvements. The need for judiciary reform in Poland stemmed from the communist past, the social perception, and officially improper power balances but the reforms implementation, in my view, seems to be improper, especially taken into account that according to the rule of law index, the word justice project, justice-oriented factors such as you can see fundamental rights, civil justice, criminal justice, and somehow open government were assessed as was done before those reforms in 2023. Fourth, the recent data hold that the applied regulations didn't strengthen the social trust in Polish judiciary. So what is the problem? What is the background? Firstly, the aim of the existence of judiciary is to provide social peace, and it was not met by the previous reforms and somehow by the recent reforms. The current need in the Polish society for the social peace can be shown by the lack of social trust in the government, which represents this category of open government. You can see that it's quite low. What should be also taken into account is the attitude of the Polish society towards changes. And it can be surprising because it's not so stiff, it's not so flexible, but it's not so stiff. I would say like it's half to half. Like we can see, there is no clear report on that. Okay. Okay, there is no clear report, but we can use some reports, for example, about our attitudes to climate changes, or this report, which shows our attitude to the reforms after the subversion of communism, and even such positive reforms like that after 1989 are not so obvious. They are positively assessed, but not like the Polish society, not exaggerated on that. And with the time, as you can see, the line is higher and higher, like so from the distance we can assess some reforms positivity, but not suddenly. However, the lawyers society, as I've asked yesterday Professor Kubu about her attitude to changes, should they be gradual, or should they be like sudden, as we experiencing now some dangers? Is like there should be gradual, because we have this legal certainty principle implemented in our thinking, I would say. So when it comes to the justice field, I would be caution while implementing some changes. Secondly, reforms to enhance judiciary independence should be made continuously, regardless of government changes, to reduce external influences, as via the linguistic analysis, reducing external influences is what independence means. And thirdly, taking into account the specific aim of disciplinary proceedings, we should pay attention to the fact that their aim is to ensure proper protection of rights at courts, not harassing judges. Actually, according to the CBO's report from December 2023, polls find the human rights, the protection, and the country's care over its citizens as the fundamental factor for the existence of democracy. You can see, like on this diagram, we have like this blue field is the country's care over its citizens, and the yellow part is about fundamental rights protection. And interestingly, and it can be somehow an answer to your question, Professor Hartwig, we found like procedural justice as somehow less important nowadays than material justice. So maybe judge father is like somehow better seen nowadays, but it was changing during the years. So what should be taken into account is the fact that especially human rights of ordinary citizens are subject to justice systems, and judges themselves, because they are also citizens, should be provided to be acceptable by the Polish society. And it can be some factor why the Polish society, the whole society protests if the judges' rights are somehow violated, because we have so much attention on protection of the human rights. Fourth, reforming disciplinary proceedings require attention to the unique background distinct from typical judicial proceedings. And now I would like to show you the current shape of these disciplinary proceedings in Poland. And I cannot. Okay, so it will be better, but it doesn't work at the. Oh, there is a mouse. Okay, okay. So it will work. So the current shape of the disciplinary proceedings. I will start the story from 2017, where there was a series of amendments to allow reconsideration of officially ended disciplinary proceedings against judges, and reforms to establish the disciplinary chamber, the position of disciplinary ombudsman. Disciplinary ombudsman is an, so to say, interesting figure, allowed to initiate investigations into possible disciplinary offenses committed by judges at the request of various authorities, but also on their own initiative after some preliminary determination of circumstances. And the whole system, and also this position, the disciplinary ombudsman, is attached to bodies such as Minister of Justice, who appoints ombudsman, and the National Council of the Judiciary. And within the years, as you can see, in the center of changes 2018, 2022, we have many investigations, like 251 cases, like there is hundreds. And when it comes to the finished cases, there are only few. So it raises some doubts if the investigations are done on the solid grounds. And okay, I will do it within the time. So let's talk about how to highlight specific problems, and how to improve specific problems. I will focus on these three: the right of defense, firstly, as it is often violated during the disciplinary proceedings due to the questionable regulations allowing actions despite a participant's absence. For example, the Article 113B of the Act on the Organization of Ordinary Courts allows actions despite absence, and it's referencing only to one paragraph from many of the Article 117 of the Polish Code of Criminal Procedure. So it's quite a shortage. In my opinion, it can be repealed and based on the Article 170 of the Polish Criminal Code on the whole, not just on the one paragraph, to encompasses via the necessary circumstances. And the other problem with disciplinary proceedings is the transparency issue. Because, for instance, the Article 109A of the Act on the Organization of Ordinary Courts says that the only sentence of guilt without justification should be made public. In my view, it should be changed, and also other rulings, not only sentencing, and also their justification should be published. And thirdly, the disciplinary ombudsman liability can be strengthened to make them at least answer the existing provisions, because in reality there is a problem, particularly since the National Council of the Judiciary, which is responsible for oversight, is dysfunctional, so it should be taken into account. And summarizing, these are reforms that can be made. Procedural small ones can be done quickly, but reorganizing the institutions require more gradual and slower changes. Both systems, Ukrainian and Polish, need some efforts to improve judicial procedures. Those procedures are specifically important for economic entrepreneurship, for our justice, for our security, and also for individual developments. Therefore, politicians, experts, yes, judges, lawyers, yes, but also citizens themselves should take part in this discussion. In this way, we can collectively contribute to building the system that will defend the rights of individuals and compensate harm done. Thank you very much for your attention.
Thank you very much. And now I would like to invite the third group of presenters who will speak about a reform, the Council of Judiciary and the Council of Justice. The paper is titled How to Reform the National Council of Judiciary in Poland and the High Council of Justice in Ukraine. And our presenters will be Maria Garmasz, Karol Kozanecki, Maciej Kozłowski, and Gabriela Dąbrowska.
Am I allowed to stay during the time, or do I have to sit? Sorry? Am I allowed to stay during the presentation, or do I have to sit?
You can go.
Okay.
It depends on you.
Okay.
If you don't mind.
Yeah, where is your presentation? It's how.
But before we move to my historical counterpart, I wanted to ask you a few warm-up questions that you surely know answers for, but the best way to gain your attention is to engage you. May I? Sure. And we've prepared the two questions, but maybe we can stick.
This question.
Yeah.
Oh, then another, the next one, yeah? This
No, that's the second slide. Okay. Oh, great. Thank you. I don't know.
I
I don't know how are you doing it. And yes, the first question is the easy one. Why do we even need the councils of the judiciary? Any ideas? Like, why are we even having that? Why Polish Parliament or Ukrainian Verkhovna Rada does not directly appoint judges to the courts. Maybe we'll stick to the person.
Germany, for example.
Sorry?
Germany, for example.
Like Germany. Yes, doctor?
Generally speaking, because of the fact that humans are make a lot of errors.
Can you explain?
So we should have no trust in humans,
In politicians,
especially.
Yes, that's true, except German politicians, of course, because we trust them. Naturally.
Apart from those who
Apart from this one, yes. So we have double negative, but we'll manage it. Yes, that's true. Like the main reason why do we even have the councils of the judiciary is to, well, ensure the impartiality of the courts, because we have the tripartite division of powers, separation of powers in the modern countries. And well, it would be quite weird if parliaments would choose directly the judges. So we created the bodies that, well, do it for them. And the second question is quite controversial because we wanted you to ask, do these councils have the same role in the Western and Eastern European democracies? But looking on our previous discussions, let's agree that well, the answer is that German judiciary is not corrupted. So the powers and the obligations are different. So, as I said, I want to first provide a brief history of the HCJ, or which can stand for the High Council of Justice, or the High Council of the Judiciary, because in English language we have the word justice, which definition is a little bit broader than in Polish and Ukrainian languages. And before the reforms of 2016, the High Council of Justice was called
Вища Рада юстиції.
Thank you. Which might be translated as High Council of Justice, but in Polish we would use the word sądownictwo, which is more justiciary, like our Polish counterpart. But after 2016, the name is
Вища Рада правосуддя.
Which is more straightforward, and we can agree that it's the High Council of Justice or Najwyższa Rada Sprawiedliwości. So, thank you. Yes, this body, the High Council of Justice, was introduced as a part of the constitutional reform of 1996 and began its functioning 2 years later. And its powers was mostly focused on appointing and dismissing judges. Because the body literally have the powers to apply for appointment and for dismissal of judges. It reviewed the cases of violations of various prohibitions by judges, such as the incompatibility of offices principle, and it was more focused on, as I said, just appointing and dismissal. And we had the 20 members who were mostly elected by the political powers, but we will delve deeply into that a little bit later after the 2016 reform, because we will see why it was interesting. And the term of membership of the members of this council was 4 years, similar to our Polish counterparts.
Well, maybe. Oh.
Yes, and this body was criticized. It was criticized by the Venice Commission, by the European Court of Human Rights, by the various NGOs, by us in our analysis, because yes, it was too politicized. You will see later how the members of this body was appointed. The influence of judges was too small because only 3 out of 20 members have been chosen by the judges, and as I said, the powers was not really focused on protecting the judicial independence. It was very limited, just to appointing judges, and it is some way of protecting the independence, but we can agree that it's a little bit not enough. After 2016, after the Euromaidan, or after the, you can call, revolution in Ukraine, one of the parts of reforming the country to, well, make it more like European states was to reform the High Council of Justice and changing its name, but not only. The introduction of this, it was not new body, but introduction of the new shape of this body was introduced as a part of the constitutional reform of 2016, and the body began its new function. The new body began its new functioning a year later. It had broader powers because it was focused on protecting the judicial independence, protecting the judges. It shaped, and it is shaping still, the judicial professionalism, the ethics and social responsibility of the judiciary. We have 21 members, which are mostly elected by judges, what we'll see in a minute. And the term of membership is still 4 years. I will try. Yes, and we've made the charts to show you what was the difference before and after 2016. Because on the left hand side we can see the HCJ before 2016, and in the color of purple, it is the third one. We can see the members which was appointed by judges. So as I said, it's only 3 out of 20, and there were various bodies which appointed the judges. It was the Parliament, the President, the Congress of Advocates, the Congress of Representatives of Law Schools, etc., etc., etc. In the HCJ, directly seated the chairperson of the Supreme Court, the Minister of Justice, and the General Prosecutor of Ukraine, which might be controversial, and it was controversial, at least the Venice Commission said so. So after 2016, after the reform, we can see that, yes, the judges are now choosing almost the half, 10 out of 21, almost the half of the body. We also have the chairperson of the Supreme Court sitting as the 11th person, so we can say that we have quite a big judicial influence on the body. And we can say that the members of the HCJ which are appointed by the political powers, there are only 4 of them, because it's the 4 members appointed by Verkhovna Rada, which is parliament, and President of Ukraine. So the influence is, the political influence, the politicization of this body is way smaller than before. And I think it's your turn.
Yeah, thank you so much. So unfortunately, I got the part with specifics and boring facts. So yeah, you will have to hear me out, but I promise it will get better. Probably I won't reach the same level of presentation as Maciek because he's incredible, but I will try my best. So the first thing that I want to talk about and that I want to tell you is basically a more specific functioning, because we already heard some things, but the main functions of the High Council of Justice include submitting to the President proposals on the appointment of judges, disciplining and dismissing judges for misconduct, disqualifying judges from administration of justice, especially due to criminal procedures, and also considering notification of judges regarding the interference with the administration of justice. And all of these powers are crucial for the maintaining of judicial independence and ensuring a high standard of conduct among judges. Also, what are the requirements for people who can enter this kind of council? The answer is, the person has to be a citizen of Ukraine who has turned 35 years old, has a good command of the state language, has a higher legal education, at least 15 professional years of experience in a sphere of law, belongs to a legal profession and meets the political neutrality criterion, as well as professional competence, professional ethics and integrity criteria, may be elected, appointed to the position of a member of a High Council of Justice. Also, members of the High Council of Justice, except the Justice of the Supreme Court, shall exercise their power on a permanent basis. The members of the High Council of Justice shall be subjected to requirements and restrictions established by the anti-corruption legislation. Members of the High Council of Justice shall be obliged to comply with the ethical standards for justice, both in professional activity and beyond it. And our last but not least, things that we already talked a bit in our first point, but it is very important, so I just want to stress it, that a member of High Council of Justice shall meet a criteria of political neutrality. In particular, a person may not be elected appointed to be a member of the High Council of Justice if, as the date of election appoints this person, so the person cannot be a member or hold any position in any political party or another organization with political goals or participate in political activities. The person cannot be elected to an elected position in any state body except judicial or in a local self-government body and holds a representative mandate. And also participants in if they cannot participate in organization of founding of a political campaign or in other political activities. So very different from Germany, as we already had. Yeah, and what I want to say next, that actually in recent years, the High Council of Justice made a lot of advances, and they have appointed a significant amount of new judges, particularly on lower levels, and that helped to address the backlog of cases. And the council has also established a procedure for the disciplinary proceedings and removal of judges accused of corruption and incompetence. But I mean, despite all these incredible things, they also have faced a lot of criticism from normal people as well as, you know, politicians, and everybody's not really satisfied. So why is that? Why is that? I want to talk more specifically about their misconducts, but we chose specifically a time period starting from the 2016, so the reform where the body changed and kind of became something new, and until the 2021. And as we will talk about it later in more detail, but right now I just want to say that in 2021, the Ethics Council was established, and it changed the procedure, and it changed kind of the perspective of our European partners, who were a great help in all of our judicial reforms, and like their perspective on High Council of Justice changed after the establishment of Ethics Council. But not that, I mean, Ethics Council solved all the problems and everything became, you know, butterflies and rainbows. But yeah, it helped. So addressing these misconducts, in my personal opinion, they are atrocious. I do not know why they happened. I do not think that. I mean, I think that they should be addressed and they should be talked more widely in the society, and that more people should understand how much these people actually, you know, they connected a lot of, they made a lot of mistakes before, and we should not forget about it, and we should remember, and we should be careful and yeah, pay close attention. So the first thing that I want to talk about, the first misconduct, is the High Council of Justice is putting a pressure on the judges of the High Anti-Corruption Court. So basically, in November 16th, 2020, the third disciplinary chamber of HCG prosecuted the investigating judge of the High Anti-Corruption Court, Vera Mikhailenko, and issued her a warning And this is the first time when disciplinary chamber of the HCJ have used a disciplinary sanction against the HACC judge. So, however, the judge, Vera Mikhailenko, in fact, was punished only for allowing an absentia investigation into Mykola Zlochevsky, the scandalous minister of ecology during the Yanukovych-Azarov presidency, and who had fled Ukraine back in 2014. So the second misconduct that I want to talk about is HCJ initiating illegal appointments of judges. So according to the constitutions, judges whose 5-year term has expired may only be appointed if they have passed the qualification assessment procedure. However, the High Council of Justice violated these requirements, and during the November and December of 2020 submitted a request to the president on the indefinite appointment of more than 50 judges who earlier had not completed a qualification assessment or had not passed it at all. So thus the Public Integrity Council approved a negative opinion regarding all those judges who had been recommended by the HCG. According to the Article 88 of the Law on the Judiciary and the Statute of Judges, in the event of a negative opinion by PAC, members of the High Qualification Commission of Judges must veto at least 11 votes in the favor, or otherwise the judge is considered not to have passed the qualification assessment. However, the High Qualification Commission of Judges did not vote any of these, did not veto any of these judges. So the third misconduct is the High Council of Justice sent judges to an honorary resignation instead of a dismissal and for their violations. So basically on April 9th, 2020, the High Council of Justice resigned Alexander Strukov, I'm sorry, and the odious head of the Oktyabrski Court of Poltava. And at the time when the members of the HCG were considering Alexander Strukov's resignation on his own violation, on April 9th, there was also 7 complaints awaiting the consideration against him, including from the prosecutor's office in Poltava region. And one of the complaints was on the agenda of HCG in a week, namely on April 15th, it concerned 170 episodes where Strukov allowed drivers accused of drunk driving to avoid responsibility. And that means that the High Council of Justice has every reason to prosecute a consideration for resignation of this judge. However, the members of High Council of Justice did not do so, and unanimously satisfied Strukov's statement. So, and thanks to HCG, Strukov resigned instead of being shamefully sent away in dismissal. And in addition, due to the resignation, Strukov received payment in amount of almost 1 million hryvnias in total for at least 3 months and 9 days of his work. He submitted in the declaration almost 2.5 million of his salary. And in retirement, Strukov will receive from 900,000 hryvnias per month for life. And if he had been deservedly dismissed, as he should have, for the violations, he would not have received this exacerbation sum and would have the right only for the regular pension. So the fourth thing is the High Council of Justice covers judges who make arbitrary decisions in the top cases. So in January 2020, the High Council of Justice refused to consider complaints against the judge of Malinovsky District Sud of Odessa, Serhiy Chervko. Dmitro Peredarko and Viktor Koroy. They acquitted with like a gross violation, and Mayor of Odessa Gennady Trokhanov and his accomplices in this case of like embezzlement of 92 million hryvnias at Odessa City Hall. And so the complaints against judges' actions were filed to the HCJ by the Specialized Anti-Corruption Prosecutor's Office and the Anti-Corruption Action Center. Judges of Malinovsky District Court of Odessa, Serhiy Cherevko, so all of them three, they committed gross violations during the trial of the mayor. However, the HCJ, they even refused to initiate the disciplinary proceedings to properly assess judges' actions. So members of the HCG explained the refusal by the fact that the case is already being heard by the Chamber of Appeal of a Supreme Anti-Corruption Court, which has to check violations regarding the decision of Malinovsky District Court of Odessa. However, the judges of the Anti-Corruption Court cannot punish colleagues for like a disciplinary violation, and because this is the function of HCG. And the fifth thing is how HCG actually actively try to block their judicial reform. So basically, the High Council of Justice blocked the implementation of the law which foreseen the complete restart of the High Qualification Commission of Judges of Ukraine and cleaning the HCG itself from dishonest members. And on October 16, 2019, members of parliament supported amendments to the law of Ukraine on the judiciary and status of judges, and some laws of Ukraine on activities of judicial authorities, initiated by the president. And on November the 7th, these amendments came into force. So the new law introduced mechanisms for restarting the High Qualification Commission of Judges and the High Council of Justice with the participation of international experts who previously had played the key role in selection of judges to the High Anti-Corruption Court, and in particular international experts who had to be included in the Competition Commission for the open competition for positions for the High Qualification Commission of Judges, and in Ethics Commission, which should have checked members of HCG regarding integrity and initiate the dismissal of those who did not meet the criteria. So basically, this is the Ethics Council that we are moving to. And so according to the law, the High Council of Justice should have confirmed the composition of commission on the ground of proposal for nominees until February the 5th, 2020. Moreover, by the time the Competition Commission should have completed the competition of High Qualification Commission of Judges. However, none of the commissions were created. And international and foreign organizations suggested three experts to the Ethics Commission on November 28, 2019. In turn, HCG should first update its own rules of procedure. Supplementing with like previous on the procedure for the delegating members to the Ethics Commission, delegate like 3 members to the members and confirm the composition of the Ethics Commission. Instead, during 3 months foreseen by the law, the High Council of Justice neither amended rules of procedure, nor delegated 3 members to the commission. So yeah, the next thing that I wanted to talk about is Ethics Council, but we don't really have a lot of time. So I am just going to explain it really quick. I will try. As we already kind of realized, the Ethics Council was created in 2021. And before that, I mean, starting from 2016, atrocious things have been happening. And basically, the establishment of this kind of body should have helped with the election process to the council. But it wasn't very effective, you know, when it was first established, it wasn't really doing anything. I mean, about the structure a little bit. The Ethics Council consisted of 6 members, 3 of them, three of them. So and also it is like one. The law is a Dash law, number 5068. So yeah, whatever. And this law creates a special one-time process for picking the first Ethics Council members, and there will be like 3 judges in this council, current or retired. So this is an interesting fact, suggested by Ukrainian Council of Judges. And 3 other candidates will be chosen by an international organizations, as it was done with the High Anti-Corruption Court back with, you know, the Public Council of International Experts. So they basically wanted to repeat this very positive experience of the High Anti-Corruption Court. But everybody was really concerned simply because the structure of the Ethics Council is different. It's very different from the High Anti-Corruption Court, and including members also from the Ukrainian Judges Council. Like, it raises concerns about whether the council might not be like fully independent and from the court system itself, and potentially limiting the effectiveness of this whole council. So, and also I wanted to just briefly mention the stages of evaluation of the candidates to the High Council of Justice. It's first analyzing the candidates' documents, of course. Then it's making a decision on admitting candidates to the interviews. Then it's interviews with candidates, and fourth is making a decision on compliance or non-compliance of a candidate for the position of the HCJ member with the criteria of integrity and professional ethics. And fifth is the publication of the list of candidates recommended for the selection. But this is a procedure for members who just applied, for new members. And what to do with the members who, you know, already exist, who already in the council, what to do with them if their, you know, impartiality, if their efficiency, if their ethics, work ethics are questionable. There is a procedure for that, and it is like evaluation of incumbent HCJ members. And it is a bit different, but it's not really, actually, because it's still first step. It's analysis of information about HCG member. The second is interviews, and the third is making decisions on compliance or non-compliance. And in case of non-compliance, of course, the person gets dismissed. And if in case of compliance, a member of HCG may remain in office. But there was a lot of problems with this. Okay, basically, what I also wanted to say, this assessment process was also highly questionable. There was a lot of problems with that, and it's like the time for the interview was too little. There was not enough the industry started to obviously exert obvious pressure on the members of the Ethics Council, and in order to delay the assessment. So yeah, they were trying to delay it. They were very, I mean, those who were already in office of the High Council of Justice, they were very against the establishment of the Ethics Council, and they even made an appeal to this whole draft law, and yeah, they were not fans of it, basically. So yeah, but it got passed, but there's still a lot of questions. And even though both Venice Commission and European Commission, they were kind of satisfied with the establishment of this kind of institution, but also not really, because I mean, they have, you know, this cautious optimism about that, because they realize that this kind of body can actually help. It can change something, but also they were really concerned about all of the internal, you know, processes that happened in the High Council of Justice, and basically they were not really sure whether yeah, and also one of the things that they offer, like recommended for a reformation, was to actually like promote more, first of all, public trust, of course, maybe change the composition of the commission itself, maybe add more members who are actually people who are trusted by society. So it can be members of the non-governmental organizations, it can be you know, human rights advocates, and just people who, yeah.
So when our time is up, we are going to the second half. So let's please change seats. And in the meantime, I will quickly provide you with the Polish history. And I know it's not very materially important to our presentation. Thank you. So I will just mention a few quick facts. That Polish National Council of the Judiciary, NCJ, was introduced in 1989, and we were the first country. Sorry. What Taylor Swift?
Can you stand? I'm joking.
And we were the first post-Soviet, I had this word, post-Soviet country which introduced such bodies. So congratulations for us. And it starts functioning in the next year. The NCJ has also the 4-year term of membership. It has very limited powers, similar to the powers of the HCJ before 2016. So it was mostly focused on applying for appointment of the judges by the president, and that was mostly all, and also the disciplinary proceedings. And it was maintained until the 1997. I would like to ask for the next slide, please. And in the 1997, as you probably know, the new Polish constitution came into force, the constitution we have today, and it expanded the powers of the NCJ. The constitution highlighted the role of this body in protecting the judicial independence. An example, the NCJ received a very important power to apply for the constitutional control of the act by the Constitutional Tribunal. So the NCJ could now can influence the appointing of bills or the appointing of the acts in the Polish law. So it's very important. What else? The NCJ does not only choose the judges that shall be appointed by the president, but the body also choose the criteria by which these judges shall be chosen. And to quickly conclude, I shall say that even the Constitutional Court in 2004, in its ruling, said that NCJ, quote, is the best representation of judges in Poland, thanks to the high percentage of members chosen by the judges. So we have a very strong organ. We have a very long history. And you will probably ask, wait, I didn't say anything about the membership and about the appointment of the members. And yes, I didn't, because that's the role of these two folks.
Yes, so the most controversial issue surrounding the composition of the National Council of the Judiciary is the selection of judges. So please focus on this sentence. 15 judges chosen from among the judges of the Supreme Court, Common Court, and other. Until 2018, there was no doubt in the doctrine that the provision formulated in this way meant that judges are elected by judges and not by other entities. It is worth mentioning that before the change, the statute provided for the exact method of selecting judges by various judicial bodies, and this did not raise any objections. Doubts arose when in 2017 the parliament amended the act and heavily changed the method of electing judges to NCG. The biggest problem with the council results from this change. The new regulation, mean that judges are not elected by judges as before, but by the Sejm, a political body. The National Council of the Judiciary should be independent from other authorities. Meanwhile, it is worth noting that before the change, only 8 out of 25 members were elected by political forces, and after the change, there are as many as 23 out of 25. Of course, there are voices that this act is contrary to the Constitution. However, the Constitutional Tribunal ruled that this provision was corresponding with the Constitution. It is worth noting that the tribunal issued such a judgment in a composition that seems to be illegal elected. But what is the main argument for the compliance of this change with the Constitution? It is very simple. If the Constitution does not say directly who makes the choice can be made by some other body, for example, the Sejm. I will present some arguments against this thesis. First, an analysis of the structure of this article. Within this article, the legislator provided information that parliamentarians are elected by the parliament. If another sentence of this article does not contain any information that Sejm elects any other entities, including judges, the competence should not be presumed to the competence of the Sejm. It is clearly defined which members are elected by the Sejm, and these are not judges. Second, over the years, it has seemed obvious that this article should be understood to mean that judges are elected by judges. Such theses could be found in commentaries on the Constitution written by specialists in this field. Moreover, this was even recognized by the Constitutional Tribunal in 2007 in the judgment K2507. Unfortunately, in 2018, the Constitutional Tribunal opposed the position of scientists and the previous line of jurisprudence. Thirdly, in line with the idea of rational legislator, it should be assumed that the lack of information in the Constitution about which body choose judges is not accidental. If it was the legislator will that judges are elected by the Sejm, a rational legislator would constantly include such information, just as they did in the case of information that deputies are elected by the Sejm. Fourthly, two types of interpretation of the Constitution can be distinguished: static and dynamic interpretation. There is no doubt that, according to the static interpretation, judges should be elected by judges, because this was the will of parliamentarians at the time the Constitution was adopted. As for dynamic interpretation, it cannot be assumed that any social changes have occurred in recent years that would justify reduction of independence of courts. The key question is the provision we are talking about too imprecise? It seems that the text of Constitution is not precise enough and is not prepared for the coming to power of people who are able to ignore the spirit of Constitution in order to implement their own political goals. We are, of course, talking here about motives for limiting the independence of judicial. So, thank you.
Okay, so I think it is safe to say that every reform can be judged in the most efficient way by analyzing its consequences. So let's look at the consequences of the judicial reform in Poland, and more specifically the NCJ, because at this point everything starts and finishes with the NCJ. If it comes to the EU perspective, well, we got weaker and isolated in the EU. Hungary is keeping us company from time to time, but I think we shall strive to be the best, or better, if that is the best we can get. The launching of the Article 7 of the Treaty on European Union Procedure was done against us for the first time in the EU history. So golden medal for us once again. Withholding of the EU funds, the post-COVID aid, that was the main source of rebuilding the economy of every European country after COVID, was conditional on restoration of the rule of law. It was by the decision of the European Commission and the CGEU. Also imposition of 1 million fine per day after we refused to abide by previous rulings from the CGEU concerning the disciplinary chamber of the Supreme Court. Later, we got lucky, it was reduced to only 500,000 daily. The suspension of the Polish NCJ's membership in the ENCJ, which is the European Network of Judiciary Councils, in 2018, and our exclusion from the ENCJ in 2021, also for the first time in history. By the way, a fun fact, we were one of the founding members of this institution. So yeah. Also, the constitutional perspective, which is, I think, the most important one from the Polish point of view. First of all, by law, and most importantly, by the highest law that we have in Poland, which is the Constitution, every citizen has a right to fair and public hearing of his case without undue delay before a competent, impartial, independent court. It's the Article 45 of the Constitution. So a right to court, constitutional right to court, basically. I think it's safe to say this right has come under great danger. Some even say it was eradicated. Also, what Maciek mentioned, the tripartite separation of powers under the rule of law, as well as the deepening of the constitutional crisis initiated in 2015. So I think it's possible to say that this reform wasn't very lucky for us. How we can reform it in compliance with the rule of law, which is also directly mentioned in Article 2 of the Polish Constitution. Let us look at the recommendations of 3 independent organizations, which is the CGEU, the Court of Justice of the European Union, the Venice Commission, and the European Commission as well. Why doesn't it work? Why isn't it working? Okay, it's not. Okay, so the CGEU ruling, I will just briefly mention it, but it was the ruling caused by an appeal of 3 Polish judges of Supreme Administrative Court and Supreme Court to the CGEU due to the disciplinary chamber. What's the most important outcome of this ruling is that the CGEU enabled national courts to perform an examination of judicial independence and impartiality of judges, thus giving our Supreme Court an authority to conduct this evaluation to the disciplinary chamber, but by extension to the NCJ itself. Like I said, it all starts and ends with NCJ at this point. So what are the factors that have to be taken into consideration while examining this judicial independence? Obviously, the procedure of appointing. This is the main issue that we came across during this reform, as well as the systemic structure of this judicial body, external independence, internal independence, the reasons of its members' exclusions and dismissals. So since we got those terms, those factors, we can perform this national test. And spoiler alert, it did not pass this test, according to our Supreme Court, I mean the NCJ. Also, CGEU, because it couldn't really decide on its own whether the disciplinary chamber and the NCJ were impartial and independent, thus they gave us the authority to perform this evaluation. They did, however, point out characteristics that are completely not objectionable, and the ones that may raise concerns at some point in case of the Polish NCJ. Well, according to the CGEU, the major participation of the NCJ itself in the process of appointing judges and the role of the president in the procedure, as well as the absence of judicial review, are not objectionable. However, the circumstances that may raise concerns about the independence and impartiality of our recently reformed NCJ are, first of all, the fact that it was created during the ongoing constitutional 4-year term of its previously appointed members, as well as the replacement of appointers of the 15 members of the NCJ from the judiciary to a qualified majority of 3/5 of members of the same. Like I said, they couldn't really tell directly that this is a problem, but they indicated that it may raise some concerns. Let's go to the Venice Commission. This draft was given in 2017 in December. Opinion on the draft, pardon me. Just after we the same decided to go on with the reform. Basically, what can be concluded from this Venice Commission opinion is that the judiciary should not be insulated from quickly changing political winds. Back in the day, our constitution was prepared, written. The authors, according to Professor Garlicki, they have never imagined a scenario where one political force will end up with having such high result in election, thus basically dividing not power into 3 separate parts, but one power into 3 parts. Those were the consequences. And the judiciary, even if a party maintains and obtains such high result, it should never influence the judiciary system. The other thing that was also mentioned by the CGEU, and you will see that it's a repeating pattern, the judicial members, the 15 judicial members of the NCJ, by no means should be ever appointed by any political force. This is unquestionable. This has been the consensus for the majority of our independent functioning post 1989. But since the Constitutional Tribunal crisis beginning in 2015, this consensus has been challenged. The same opinion basically was given by the European Commission. The political appointments of judges members, the premature termination, thank you. The premature termination of mandates of the current judges members of the Council therefore violates the principles of separation of powers and judicial independence. We were given some specific recommendations. For example, we have to ensure that the law on the NCJ is amended so that the mandate of judges members of the NCJ is not terminated and the new appointment regime is removed in order to ensure election of judges members by their peers. It got terminated, spoiler alert, but yeah, we should at least return to the previous version that we had. Also, first and foremost, the European Union itself doesn't have judiciary on its own. I mean, it has the CGEU, obviously, but the Polish judge, any judge who is also a member, who is also originating in a country of the European Union, is also a European judge. So that's why we should maintain those standards, because, well, if you want to pretend to this title of being an independent European country, we should uphold those standards. I think it's without question. Fun fact, the Article 7 of TEU procedure has been terminated recently in May, because our government our current government, started to work on major changes in our political system. I think one of the most important changes is that we are heading in this direction to going back to this previous procedure of appointing our member judges of the NCJ. If you compare those two versions, the 2011 version and the current version, which is under proceedings as we speak, it got even more diverse. But yeah, the basic idea is the same. It's not a competence of same anymore. It's the competence of the judges and the judges only. Other changes were introduced. Like I told you, this is currently on this level where the Sejm voted. The Senate made some amendments, and now it has to be taken back to the Sejm, so the Sejm can vote on the amendments of the Senate. And then it's the president's turn. First of all, we have never had a National Election Commission, which usually deals with organizing election, general election, local election in Poland, to be involved in the process of applicating the candidates, reviewing those candidates, judges candidates to the NCJ. This is a very new solution. Also, there has to be a public hearing procedure. One of the most controversial changes was that those so-called neo-judges, this is the kind of nomenclature we use in Poland sometimes to describe the judges that were appointed by this post-reform NCJ. Well, the first draft of this project didn't really give them an opportunity to be reappointed. It was just, if you were elected by that council, you are done, you're no longer a judge. The Senate amended that. It was also proposed by the president to enable those judges to be reappointed in a proper way, constitutional way, first of all. Also, there is to be a social council to be created. Okay, I'm finishing, which is going to give that social factor into the judiciary system, and is going to ensure greater public control. So this is our concluding points. How does the rule of law apply to the new proposal of the reform, and how does the new proposal apply to the rule of law? Well, first of all, I think it's safe to say we got back on good tracks because we originated in this constitutional way of appointing judges by judges. Well, there were a few upside downs, but I think it's safe to say that we're going back to the right direction. Also, the social council, of course, it can be disputed, but in our opinion, it may increase the participation of social factor in the justice system, which is also articulated in Article 187 of Constitution. The National Electoral Commission is kind of controversial, I'd say, because from what we've discussed, it might be a good option, but the NEC isn't really that keen on being involved in that because they just don't consider themselves competent enough or educated enough on the matter. And also a question that we would love to hear your replies is, how do we prevent the history from repeating itself? I think it's not controversial to say that enshrining, a clear enshrining of the competence of judges to appoint other judges to the NCJ in the Article 187 is essential at this point. Because, well, we never thought we would come to this, but we did. So let us not repeat that mistake. Okay, so I think that's it. We really thank you for your attention and hope for your support.
Okay, so thank you very much for all great contributions. Our situation is very difficult, but I think that we have two questions. Okay, yeah.
One thing we'll start with the 9 months period for the average proceeding, whether it's civil or criminal. I think it's a good result. Germany is good. So therefore, 9 months is fine. Italy will invite, it is all permanently convicted by the European Court of Human Rights for violating the principle of proceeding in reasonable time. So I think 9 months is okay. Salary discrepancies, depending on the situation, perhaps is much cheaper than Warsaw. So there must be, just to see the difference, this is not sufficient, you know. I would say, as for the change of the proceeding, we have in Germany now more and more the question of mediation in civil cases, in administrative cases, in the plea bargaining, borrowed from the United States. Personally, I'm quite skeptical having the continental European education. And then I had a personal experience. We had involved in a case, civil case. I'm not a civil lawyer, but I was completely convinced that I was right. And then the judge made some pressure, they make mediation. Why? Because if there's a mediation, you just have to write down, and then no motivation, no foundation of the decision. For him, it's a very quick thing, within 5 minutes. And I did not agree. And in the end, I won the case. And I was deeply disappointed by this pressure exercised by the judge threatening me, saying, but if you don't agree, you don't know what the result will be. This is a problematic thing. Yeah, we talk about corruption, but in case Alays overwhelmed this work, yeah, this is therefore they are in favor of this mediation. In principle, it's a good thing, and we should think of it, but use it in the right way. And now to the cases, you know, with disciplinary measures against judges, I'm very reluctant. Okay, if there are no corruption, no disciplinary measures. You could also say the other way around. If there are no disciplinary measures, how can you know that there is corruption? You know, but in Germany, there's almost no disciplinary measures. There's in 70 years, 5 cases or so. Normally, because the judges did not do their work, overwhelmed with work, and then in the end they became depressed and couldn't do anything anymore, and then they were subject to disciplinary measures. But now coming to specifically to Ukraine, you know, for example, the chief prosecutor, you know, she had a high reputation in Germany. In our newspaper, all of a sudden she disappeared. I don't know why. Now she's ambassador in Switzerland. What happened there? What does it mean, disciplinary measure in such a situation? We can continue for hours to this end. With regard to Poland, the situation, what do you do with the Constitutional Court? The Constitutional Court, if you say the judges have been appointed in the wrong way, but they are for a certain time for 9 years. And now we have to look at it. Can we say that the Europeans may always criticize Poland and also Ukraine, but then when they take measures, like in 2014 with Ukraine, like with Pitsky, then they'll beware you must not interfere into the independence of the judiciary. But I do not have any recommendation. How do you deal with these situations? When the judges, you know, the judges have been appointed the wrong way for political reasons, but now we have to live there for another 9 years or 6 years or whatever. And they have a huge influence. I would like to get an answer to it. Thank you.
Sure. No,
Thank you. First of all, I would like to congratulate our Ukrainian friends. You are very, very brave. I hope that you won't seek asylum in Poland after this conference, after talking about the bribe problem in the Ukrainian judiciary. My first question pertains to the speech on the salaries of the court's employees. It is very, very worth to say something about money. That's all about the money. It is important because why do we have in Poland money in the budget? Haushalt auf Deutsch, Haushaltsgesetz, yeah. For anti-judges in the Constitutional Tribunal, we have the new government in Poland. We have the resolution of the same from March 2024, in which it is written that some judges of the Constitutional Tribunal are, in fact, only persons who believe that they are judges of the Constitutional Tribunal because they were elected illegally. And my question to Mr. Adam Domański, who is the Minister of Finance in Poland currently, is why, after this resolution of the Sejm, why do we give 35 or more thousand zlotys each month to Mr. Mariusz M, to Mr. Justin P, and Mr. Jarosław W? This is my first question. And what pertains to the problem of the National Council of Judiciary is, I fully agree with the conclusion. It was very, very important and that you formulated this de lege ferenda postulate to change Article 187 of the Polish Constitution. Of course, I'm a defender of this constitution, but it is impossible to say reasonably that it's perfect. Article 187, paragraph 1st, point 2 is badly written. Probably Professor Gawlicki says true that nobody even thought about different things that passed in the future, but we should take advantage of this experience and amend Article 187, paragraph 1st, point 2, because it was very, very easy to demolish the National Council of Judiciary because of the fact that there is nothing about the body which should elect the 15 judges out of 25 to the National Council of Judiciary. It was also written in the arrested book of Professor Wojciech Brzozowski. The book is entitled Niezależność konstytucyjnego organu państwa i jej ochrona. It is published in 2015 or 16 by the same publishing, and the director from this institution, public institution, decided to arrest the book. It's not from the past, it's not from the communist period of time in Poland, it's from 8 years ago. Yeah. And there was written by Professor Wojciech Brzozowski, the current deputy of the Commissioner for Human Rights in Poland. There was written that Article 187, paragraph 1st, point 2 has to be amended. And I think that your conclusion was very, very important, and thank you for that.
Thank you very much. Okay, so the last question, yeah.
Yeah, I will try to be very brief. I know the lunch is ready for us. First of all, I am very positively impressed by both Polish reports and Ukrainian reports, and I'm confident that both Polish legal system, Polish justice, and Ukrainian has a future, a future of young generations. I'm very, really impressed. And I have only two comments, not questions, maybe remarks regarding two sessions on reforming Supreme Court and High Council of Justice. And it relates to external factors influence this reform. Yesterday and today we were discussing about influence of international organizations, EU, Council of Europe, of reform of Ukraine. But my main point is that we also should take into account our external but Ukrainian factors. These are two. First is, I would say, internal resistance of judicial system, both in reforming like Supreme Court. Today mentioned it that justices elected new head of Supreme Court with not good background of internet yet. And also it pertains to the High Council of Justice, as we mentioned. And my actually question maybe or a concern is how we can influence, how we can fight this internal resistance of judicial system in Ukraine. And second factor is we all in Ukraine know informal practices. We can speak a lot about legal technicalities, but if it goes about the office of the president, each president have as any person in the office who is so-called responsible for judicial system, who is like moderator of judicial system. It was during Yanukovych, very famous Portnoy, Andriy Portnoy. It was even in the vote of decision against Ukraine of the European Court of Human Rights, where it was worded that a man responsible for the judicial system in Ukraine with abbreviation SK. And everyone knows in Ukraine that it was Rehitiva. Yeah, and each president like Poroshenko has Alexei Filatov, Zelensky, Smirnov, and now Irina Mudra, and everyone in judicial system knows that they are like influence the judicial system. And my concern is if we want generally conduct the reform of judiciary in Ukraine, we need also target also raise these questions about real influence of the office of president. It's actually is not constitutional body with relevant authorities that can influence judicial system. And my like the recommendation to maybe suggestion for students also think about broader factors, not only legal context, but also political context and social context. Thank you.
Okay, thank you very much. So we have to end this panel. I hope that we will continue our discussion during the lunch break. So thank you very much. The lunch break is the same. Independent reports and judges is. And for example, Venice Commission states that the judiciary should be independent, and independence means that the judiciary is free from external pressure and is not subject to political influence or manipulation, in particular by the executive branch. So it can be said that independent courts are fundamental elements in every country's legal system that ensure the proper functioning of this rule of law principles, the checks and balances system. And they make it possible for us to have access to one of the basic human rights, the right to a fair and public hearing in reasonable time by an independent and impartial court, which is, as we know, enshrined in the European Convention of Human Rights. And to begin with, I'd like to present our plan. For the presentation. And would like to underline that we will start with naming the problems that we had with independence of courts, the judges in Ukraine, then solutions that can be implemented in Ukraine to deal with those problems, and then the same for Poland. And in the end, we will try to be brief as possible. We'll do a comparative analysis of our issues and solutions too. To begin with, I'd like to start with problems of independence of courts and judges in Ukraine. And Thomas and Suraj started stating that the European Court of Human Rights, in the case of Campbell versus the UK, highlighted 4 elements that together create judicial independence, as we know, and one of them being the term of office, which you can see there. And speaking of which, judges in Ukraine previously used to be appointed for 5 years. It was considered as sort of probationary period for them, after which their candidature had to be approved by the Verkhovna Rada, which as we know is the legislative organ of Ukraine. However, in 2016, a new law came into force. We changed the constitution of Ukraine and changed mainly the previous procedure for appointing judges. And this probationary term, 5 years, it was cancelled. And the new organ was created, which is the High Council of Justice, which will be heard about, and its main tasks include to be with appointing and dismissing judges, which we can say really improved the quality and transparency of the procedure of appointing judges in Ukraine in general. Then, speaking of appointing judges, it seems important to mention the next problem, which is connected to the dismissal of judges, particularly the disciplinary measures and the terms on which the judges can be dismissed in general. And speaking of which, before those reforms in 2016 were made, a possible reason for a dismissal of a judge was a violation of an oath. And this reason was formulated really vaguely in the legislation, which created precedents where judges who were, if you can say so, undesirable were legally dismissed. And the reasoning for the dismissal was this particular reason, the violation of an oath. And one well-known example, which we heard in the question previously, is the case of Alexander Volkov versus Ukraine in the European Court of Human Rights, where Mr. Volkov was dismissed due to this particular reason, the violation of an oath. And of course, the court ruled that the procedure of his dismissal was non-independent. But what is more important for us, the court highlighted several issues in the Ukrainian judicial system, which then caused a large-scale reforms in the judicial system of Ukraine, and namely, it included some changes to the constitution of Ukraine, the creation of High Council of Justice, the Public Integrity Council, the resumption of work of the High Qualification Commission of Judges, and also the Highest Court of Ukraine was relaunched, like we talked yesterday, to deal with the term of a judge. We need to ensure that they're not corrupted so that we do not insert them in this state. And moving on.
Okay, so as for the next aspect within which question arises is the Public Integrity Council. Actually, this is independent civil body that assists the High Qualification Commission of Judges in the assessment of current judges and selection of candidates for judicial positions. However, we wouldn't mention this problem if there weren't any negative effect in this work. First of all, many questions related to the Public Integrity Council's work were caused by the uncertainty of the legal status body, its duties and responsibilities caused by the lack of legislation on the work of the Public Integrity Council. Another problem faced by the Public Integrity Council is a lack of resources and a huge amount of the workload that Public Integrity Council is actually exercising the powers granted by the state to the excess qualification of judges. However, there's where the next problem stems from, and in general, the Public Integrity Council should work on a voluntary basis, which unfortunately doesn't correspond to this huge amount of the workload. The next problem, it's worth noting that it's a staffing process, and the judicial system of Ukraine, it's rather like large scale and serious problems that negatively affect the administration of justice and functioning of judiciary. And it's worth noting that today the courts of Ukraine lack about 2,000 judges, which is almost the third of the current number. And this leads to, again, an excessive workload for judges who remains in office and also delays the consideration of cases.
Moving on, we mentioned some problems connected to the independence of courts in Ukraine, and now I'd like to move to some problems connected to the independence of individual judges in Ukraine. And these like this. In this context, the first and arguably the main issue here is corruption. And speaking of it among judges, it's particularly important to mention few cases. We will not stop on them, but I'd like to still mention them. The first here being the case of Mykola Chauch, who is a former judge of Dnipro District Court of Kyiv. He was sentenced for prison
for receiving a bribe of more than $100,000. And another case that seems to me more international to look at that is the case of Knyazov, several Knyazov who, in this case, showed us that corruption in Ukraine happens, unfortunately, even at the level of the highest judicial institution in Ukraine, which is the Supreme Court now. And even after the reforms, even after the court was newly established. And this case became quite high profile in the media of Ukraine. Since after that point, we in Ukraine had never served a corruption notice to a person of such a high rank. And most importantly, the above-mentioned cases really affect the public trust in judges, obviously, which directly causes the undermining of trust to the court system itself, which is exactly the reason for why this problem is considered as one of the most urgent and one of the most pressing.
To proceed, it's crucial to mention the problem of politicization among the current judiciary. And before the reforms in 2016 were implemented, the process of appointing judges raised doubts about the independence of judiciary in Ukraine. And as it was already mentioned, a judge was appointed for the first time for only 5 years, after which the Verkhovna Rada had to let them go live by submitting their candidature, which was a challenge for proper functioning of checks and balances system. However, since the judicial system in Ukraine has undergone several reforms in 2016 and 2021, now the process of appointing judges in Ukraine is considered like the one of the most transparent in the world. For example, a candidate for a position of judge in Supreme Court submits free declaration, also passes 3 different tests, and then such person can be interviewed. And the process of interview is being broadcasted live on YouTube, as will be mentioned today. Right. And the next issue here, considering these cases of corruption among judiciary and generally the constant distrust in the judiciary in Ukraine causes the next problem, which is the foundational problem we take here, which is lack of the legal culture itself among Ukrainian citizens. And we're not talking here about law students, about lawyers, about professors, as we have here, we're talking about general Ukrainians. But here the main problem stems from the fact that our legal culture was formed in the USSR times. And unfortunately, as a society, general Ukrainian continues to perceive the law as a tool for achieving political goals or as an instrument of coercion rather than a system of social relations that can protect their human rights. And the problem with corruption particularly is one of the aspects that aggravates the lack of legal culture in Ukraine. It contributes to the development of legal nihilism in Ukraine. And it also undermines the foundations of the legal consciousness of citizens, which causes distrust in legal institutions, especially in courts. And moving on, thanks. We would like to name some solutions that we think would be suitable to strengthen the independence of courts and judges in Ukraine. And as we mentioned earlier numerous times, corruption remains a widespread problem in Ukraine, unfortunately. And in order to overcome it, we need some comprehensive measures. And the best variant, it seems to us, is to look for the practice of other countries that have also been affected by corruption, considering the situation in Ukraine, of course. And we would like to suggest looking at the practice of 3 different countries, which are namely Estonia, Finland, and Singapore. Okay, then I'll start with Estonia, and it was saying that for the last 30 years, Estonia has made significant progress in processing of fighting corruption, which can be seen, for example, in placement Estonia in the corruption perception index list from 9th place in 1990 to the 14th place in 2022. Considering the rise of overcome corruption on the example of Estonia, a number of key measures can be identified, and including emergence of leaders who are unwavering in their opposition to corruption and changes in the country's judicial system. By that, we mean that Estonia has introduced certain changes in its judicial and governmental systems.
To achieve this, the first step in reforming the judicial system was to fully ensure the independence of the courts. The state adopted certain laws that ensure the independence of judiciary with the inability of other branches of power somehow interfere in its work. Next, I'd like to talk about Finland. And this state is considered as one of the least corrupted countries in the world. Generally, Finland has done an effective work in fighting corruption, first of all by introducing amendments to the criminal code. That, regardless of who offender is, they will be held liable for corrupt acts. And another important aspect is that civil servants have high material and social security, which generally reduces corruption-related risks. And similar to Finland's experience, we are going to talk about Singapore. Singapore has also managed to minimize the level of corruption by reducing the situation that create opportunities for corrupt practices and the avoidance of punishment. So the Prevention of Corruption Act of the Singapore contains a list of articles that provides for imprisonment, or it can be also a fine for a person who has committed a corrupt act.
Moving on, we can see at the same slide. And we mentioned the problem of the legal culture. And as you can see on the slide, number 2 and number 3, there are 2 solutions. So if we speak about sorting out the problem of the legal culture in Ukraine, and we speak particularly about the legal education, it's pretty obvious that it's done through inclusion of certain legal disciplines in the curriculum of secondary and higher education institutions, and maybe at the national level, where a special course can be launched for the population of Ukraine, which may contribute to raising the level of legal culture in Ukraine, and which would hopefully foster respect for humanistic legal ideas and will lead to a change in the collective perception of law, which we mentioned. And speaking of the second one, the democratization process, it may be done by increasing the activity of citizens in the lawmaking process through public discussion and draft laws, since ensuring participation of citizens in decision-making in legal aspects leads in general to greater trust in legal elite, which is really needed, it seems to us, in Ukraine. And we have a few examples of implementing such systems in Germany and in Sweden. And Germany has a system, please correct me if I'm wrong, Bürgerbeteiligung. And this system, the German government uses this system, this platform, to gather public opinion on various legislative proposals and governmental projects. And Sweden has a similar system called Remissförfarande, which is kind of a public consultation process, and during which draft laws and some proposals from the government are sent to the citizens for their comments to obviously ensure the different points of view are taken into account before the law is adopted.
To make the situation with the independence of judges as it works in Ukraine better, it's important to mention one final solution. And in its opinion on Ukraine's application for EU membership, the European Commission noted that Ukraine should reform the constitutional code in line with the recommendations of Venice Commission. For that, a new draft law was subsequently developed and registered, which provided for the establishment for the new independent body, and I'm talking about advisory group of experts. The purpose of this body is to assess some moral qualities and level of professional competence of all the candidates for the position of judges and the Constitutional Court of Ukraine. And speaking of the advisory group of experts, firstly, it's worth noting that this institution should provide the names of judicial candidates together with an assessment of their moral qualities and professional competence. And secondly, the number of members of the advisory group of experts should be increased from 6 to 7. And this is due to the fact that it will include international experts to ensure more efficient work and a high quality process of selecting judicial candidates.
And now the floor is for our Polish colleagues, who will present same ideas from the same.
Okay, so our Polish part, I will start talk about the problems, and after we will also propose some solutions. But for now, some general remarks about the independence of the courts in our country. According to Polish constitution, the political system is based on the division and balance of legislative power, executive power, and judicial power. It is our Article 10 of our constitution, and the aim is to remain the balance. So each power must be separated, but also they need to cooperate between each other in a democratic state. These authorities need to balance each other without excessive interference in the activities of each of them. Our research refers the jurisprudence aspect. So, to ensure the mentioned balance, courts and judges must be independent. It's clear for us all. After all this year, this day, the judicial power is represented by independent courts and independent judges. Independent courts constitute the basis of the democratic system, which means lack of external pressure from other authorities on the judicial activity of judges, who benefit their independence from the two major guarantees. The guarantee of irremovability and non-transferability. In addition, judges should remain also their internal independence. And by internal independence, I mean it means that judges must have an absolute inner sense of freedom from any pressure. But since 2016, numerous violations of the above mentioned rules have been observed in Poland due to unauthorized interference of the legislative authority in the activities of the courts, to the international independence of judges. This interference concerns conducting disciplinary proceedings against judges, they forced transfers to other courts, and problems with appointment status of judges. First of all, I would like to present the problem with disciplinary proceedings, because according to according to the Polish constitution, judges are irremovable. Due to this rule, recall of the judge from office may occur by virtue of that judgment, and only by virtue of that judgment. So the disciplinary proceedings may only be initiated in conjunction with serious betrayal of dignity of the office, or in the event of a crime, when a judge committed a crime, of course. And there's also one thing, but it will be at the end. However, it is prohibited to conduct the disciplinary proceedings against judges for their judicial activities or for the judiciary work. In 2018, Polish Parliament adopted an amendment to the Supreme Court Act, establishing the new chamber of Supreme Court, the disciplinary chamber, to consider disciplinary cases of judges. But the problem is that, in consequence, the number of disciplinary cases has risen significantly. And according to experts, the new chamber was appointed incorrectly, and its members were nominated by politicians of the ruling party. Other problem is the subject of the disciplinary proceedings, because yesterday we had a very great speech about the judicial freedom of speech, and it's important for us because it was informally emphasized that the disciplinary chamber main task was to repress those judges who openly oppose the actions of the state authorities. Due to increased protest and critical opinion in the country and in Europe, in 2022, the disciplinary chamber was replaced by professional responsibility chamber, which, however, still does not meet the requirements of independence because its adjudicators are people directly or indirectly appointed by politicians. Second problem is the transfers of judges. It's also very important because a transfer of a judge to another bench or another position against his will may only occur by virtue of a court judgment, just like the disciplinary proceeding. By transfer, we mean it's change the place of the adjudication or change the judicial department. So, for example, we can transfer one judge from one part of the country to other, but also we can change the department. For example, the department from the criminal department to civil department. So the normal procedure for the transfer is that disciplinary court adjudicates about the transfer, and the Minister of Justice is obligated by this judgment about the transfer. Before 2017, a judge could not be transferred by the Minister of Justice without permission of a disciplinary court. But there was some changes in law between 2016 2023, and the administrative powers of the Minister of Justice were regularly expanded, and at the same time, the competences of judges, self-government in courts were reduced. In consequence, currently law provides the numerous exceptions of transfers without the permission of disciplinary court. My favorite example is in Act on the System of Common Courts. A judge's consent is not required to be transferred to another division if no other judge in the division from which the transfer takes place has consented to the transfer. So, how can we make it? We search a group of judges, and we are the Minister of Justice. We order a transfer. Last of these judges in that group won't be able to refuse, so he will be transferred. As I said, an official transfer includes a change of the place from one part, from one building of the court or the department. Okay, and the last problem, it's the problem that was mentioned before. It's the problem with appointments of judges from the new National Council for the Judiciary. It's on the basis to the Act of on December the 8th, 2017. It was a fundamental change that made the status and structure of the National Council of Judiciary. As I said, it was mentioned before, but for now, from our point of view, from the point of view of our research, the main problem refers to the independence of the National Council for the Judiciary, because this council plays an active role in the judicial appointment procedures by evaluating candidates for judiciary posts and submitting proposals for judicial appointments to the Polish president. As a consequence, those also allows to the position judges evaluated and also appointed by the new National Council. In some research on this topic, since 2018, the Council has assessed several thousand candidates for court judges at all levels. So it's also a promotion but also an appointment. And also this new council has appointed the disciplinary chamber of the Supreme Court. In this way, participants of court proceedings began to undermine the judgments issued by these judges, which led to a chaos in the court system. In view of the above, the regulation on the exclusion of a judge began to be used as a legal tool to remove persons commonly recognized by so-called neo-judges, we had this definition before, from issuing judgments in cases pending before the courts. And currently, it is impossible to clearly assess whether each of the judges appointed after 2018 meets the formal and substantive requirements to exercise judge. As for me, the main problem here was mentioned yesterday by Professor Molitano, which evaluation criteria we have to apply, and it will be the part of my colleague.
Good afternoon. It is a pleasure to be here. I cannot possibly claim to provide you with solutions how to strengthen the independence of courts and judges in 7 minutes, but I will do my best to do so. 4 minutes then. All right. I just wanted to say that I wanted to focus on the things that I find the most interesting and crucial. And also, I believe that our paper and our presentation is sort of a culmination of this whole day, because we address most of the issues, that we talked about today is connected very strongly with independence of courts and judges. And as for Poland, I believe that the most important word and the most word that we can use for the process of strengthening the independence of courts and judges will be the restoration. So I wanted to first address that it is necessary to consider the international response to the challenges currently facing Poland, because to restore its position within the European Union and the Council of Europe, as well as to rebuild trust in its institutions and its image as a democratic country that implements the rule of law, Poland must fully implement reforms that address the concerns of the international community, and it is therefore necessary to focus on the judgments of the Court of Justice and European Court of Human Rights and reports that were specifically addressed to Poland. However, it is also important to have the bigger picture in mind, because once the immediate crisis is resolved, it probably will be possible to focus on other reforms of other institutions that were not directly challenged, but which are only seemingly neutral. And for example, in the last semester, I wrote a paper on the suspension of a judge from office in light of the principle of irremovability of judges. And I think this is an interesting example of reforms that could happen later, because when it was introduced, when this provision was first introduced, it was decided by the Constitutional Tribunal as constitutional, and later, because of the wording, it was abused in a way that really weakened the independence of judges. But moving on, I will try to do it very quickly. As Gabriela already mentioned, the European Commission has decided to close the Article 7, Section 1 TEU procedure for Poland, with conclusion that there is no longer a clear risk of a serious breach of the rule of law in Poland within the meaning of that provision, and generally approving of the measures that have been launched so far, trusting that Poland is committed to implementing all the judgments of the Court of Justice of the European Union and the ECHR related to judicial independence. And the European Commission seems to be content with the so-called action plan presented by the current Minister of Justice. And in my part of presentation, I tried to use the latest rule of law report prepared by the European Commission as a starting point, but it was issued in 2023, and therefore it's probably in some ways outdated, but for lack of a better source, since the 2024 edition has not yet been released, I will address some key issues from this report. First, I wanted to speak a little bit about the disciplinary measures and the issues concerned, because the first topic that I wanted to speak about is guarantees against outside pressure. And this is why we even focus on disciplinary measures. And this is why we focus on non-transferability of judges and irremovability of judges. And as to disciplinary measures, we have, I think, at least two crucial problems. First one is what to do with the professional responsibility chamber that replaced the disciplinary chamber. It is said that it was mentioned in the action plan that it will be removed. The second issue is we need a reform aimed to exclude the incidents of initiating disciplinary investigations due to the content of judicial decisions. And it is also said that judges will be once again responsible only for clear and flagrant violation of the law and other behavior that offend the dignity of a judge, which I still think is one of those provisions that could be abused in the case of the rule of law backsliding again. And the third thing that I wanted to address is I believe it is necessary to reduce the superintendence and administrative powers of the Minister of Justice over the functioning of the courts, especially in the case of future possible rule of law backsliding again, because it cannot depend on a good person being in power. As to non-transferability of judges and irremovability of judges, it is very closely connected with the disciplinary measures that were already spoken about. As to the judicial appointments, the reason I'm speaking about this is the European Network of Councils for the Judiciary's methodology for assessment of the independence of judiciary listed so-called human resource decisions about judges, including selection, appointment, and dismissal among crucial elements of the objective independence of the judiciary as a whole and independence of an individual judge. And under those categories, I believe it fall Polish issues with the position of the Council of the Judiciary. And in this regard, it must be noted, as it was already before, that Sejm has adopted an amendment to the Act on the National Council of the Judiciary. And there were some controversies concerning the amendments added by Senate. However, it seems that non-governmental organizations seem to support the legislative measure taken, and the basic assumption of this amendment is to reduce the participation of the legislative authority in the process of appointing council members, as was already spoken about. However, there are still two very pressing issues. First is that the National Council of the Judiciary is still working right now in its flawed form, which some claim adds the so-called neo-judges into the system instead of at least being frozen in some way by implementing the decisions of international courts. And the second issue is how to treat neo-judges. And to this point, it is worth mentioning that since 2022, a procedure for examining the impartiality and independence of judges, individual judges, has been adopted in Poland. However, it is very controversial, and the decisions that are made based on this this procedure are also deemed controversial. The last thing I wanted to talk about briefly is the figure of a judge and what judges themselves as actors can do to preserve their own independence, because I believe that Poland was the behavior of Polish judges was very brings me kind of a bit of hope in a way that a lot of them challenged their rights, the infringement of the rights before the international courts. And to this point, I wanted to speak about the ASJP case before the Court of Justice of the European Union, which is also known as the case about the Portuguese judges. And I think that because this case provided a test that helps to decide whether a national measure affects the independence of national judges, I think it is this judgment is a very interesting example of how judges themselves can use European law and European institutions to preserve their own independence by now applying this test while ruling on the national measures that are intended to limit the independence of courts and judges. And by applying this standard, and also there are a few more things that judges can do within the European Union, which Polish judges could do maybe in the future, hopefully not, but maybe. And the first possibility is to challenge such measures, national measures, on the basis of Article 19, Section 1 of the Treaty of the European Union. Secondly, is they could ask preliminary questions to the Court of Justice. Thirdly, they could ask the Court of Justice to adopt some interim measures. And fourthly, lodge infringement complaint with the European Commission. And the last thing I wanted to speak about is that judges can also somehow actively organize themselves in some I mean, in foundations or some sorts of associations that fight for the independence of judges, and that will be all from my part.
Okay, thank you very much. You have 5 minutes over the schedule. I will think about consequences after the session because now we have 6.
Can we take 4 or 3 more minutes? Yeah.
Okay. Okay.
The
last one.
Yeah, because we prepared a little bit of comparative analysis.
Okay, so 2 minutes here and 2 minutes. Here.
Okay, so short comparison. Despite many cultural and historical differences, both Ukrainian and Polish legal systems have common roots. It comes from the European legal tradition, based on the European Convention on Human Rights and the case law of the European Court of Human Rights. Norms and standards established by European Union also play a significant role in appointing a democratic state of law. On this basis, it can be assumed that both Ukraine and Poland face common challenges in this subject to develop the independence of courts and independent judges from the internal independence. First of all, attention should be paid to the important role of the principle of irremovability of judges. And this principle is ensured by limiting as much as possible the reasons for which they may be removed from office. Therefore, we can name 3 types of cases when we can remove a judge from office, and it works in Ukraine and in Poland. It is the betrayal of the dignity of the office. It is a crime when judge commits a crime, and the vis maior. Vis maior, it's the type of situation when judge cannot work, cannot make the judgments. For example, it's a long-term illness that prevents him from performing his functions. Therefore, it is unacceptable to remove judges because of the judgments, because the judgments can only be changed by in the ordinary review system and not by politicians. An equally important aspect of protecting the independence of courts is material and economic aspect. Courts and other bodies in the judiciary should have the proper funds to function. This principle also applies to judges, who must be granted fair remuneration and, moreover, working conditions enabling them to properly perform their assigned tasks. Both in Poland and Ukraine, a huge problem is the burden on the courts with the number of cases and the length of court proceedings, which result from complicated procedure, the number of court cases, and also a staff shortage. But taking into account the above mentioned aspects, it should be stated that both the Polish and Ukrainian judicial systems are struggling with many problems, of course, but to us, these problems are not absolute, so they can be solved gradually. And for the Ukrainian part,
Our Polish colleagues focus more on the common issues, while we would like to focus more on the different issues. And the first one is the politicization, and we firstly move that to the common issues because regarding the problem of politicization, this issue has been relatively overcome in Ukraine, as often reference in 2016 were made, where the High Council of Justice was created, the High Unification Commission of Judges was re-established. The process of appointing judges became more transparent. It no longer raises such major doubts among Ukrainian citizens about the independence of the judges appointed. However, this issue is more, we can say, urgent in Poland, as after large-scale changes to the status and the structure of the National Council of Judges in Poland, which we mentioned today, members of the council are elected now by the parliament, which obviously contradicts with the principle of the separation of powers, and it can be concluded that mainly the politicization among the judiciary can be noticed in similar aspects in Ukrainian Poland, especially in the process of appointment. But here is the different issues in Ukraine. As we mentioned, the problem mainly was referenced in the process of appointing judges directly, which was Poland responsible for that at that time. While in Poland, it is more in the process of appointing members of the National Council of the Judiciary, which is also responsible for appointing judges. And speaking of the first different issue, which is corruption, as we already mentioned several times, it's unfortunately one of the most pressing issues in Ukraine, since we witnessed those cases of judges being involved in corruption issues. And this issue is not such high profile in Poland. On the other hand, not as great as in Germany, obviously. But we can see that difference visually, according, for example, to the Corruption Perception Index, where as of 2023, Poland was on the 47th place, while Ukraine was on the 104th.
And actually, moving to the last issue, it's the lack of legal culture. It's worth noting that, first of all, initially, most legislation of Ukraine and Poland was influenced by USSR. However, there was one key factor that was crucial in formulating a clear concept of democracy and the rule of law in Polish jurisdiction and among Polish people in general. And this factor was Poland's accession to European Union, which helped Poland to reach the level of culture to where it's now. And in contrast, Ukraine unfortunately remained to the close relations with Russia and until 2015, and which caused us a step back, because since all the political cooperation with Russia usually leads to the takeover of economical and political processes in that country, that consequently leads to the lack of legal culture, which, as we mentioned before, it very, very badly affect the independence of judges.
We would like to thank you for your attention.
To the second presentation by Kamila and Victor, which is entitled "How to Increase Trust in the Judiciary in Poland and Ukraine."
Hello, can you hear me?
Okay.
Yes, we can hear you.
Great.
We haven't negotiated on the time, but I'm in the position of power and decide to give you 15 minutes.
15?
15, yeah?
Can I have some?
16.
Maybe, sir? Yeah, we have a very big survey. It will be interesting.
Don't waste time.
No, don't
Okay,
waste time.
20 minutes, okay.
Okay, so first of all, experience has shown that public trust in any phenomenon, especially in the social political sphere, is very fragile. Since the human brain is designed to remember negative aspects of our lives better than the others, the long-term formation of public trust in and opinion can be affected by one specific high-profile case that overshadows years of effort to create a stable system. And trust in institutions is vital for modern democracy because it directly influences effective communication between the government and citizens. And we must remember that trust is a very complex stuff. It's shaped by personal perceptions, stereotypes, and interactions between people. It depends on both satisfaction with the courts and verified or even unverified perceptions. And the judiciary, as a key governmental pillar, needs high trust for its legitimacy. Furthermore, the fact that our courts are effective is not enough. People must believe in it. So, in today's topic, we will discuss four aspects. First of all, overview on the problem. Second, its challenges for Ukrainian and Poland judiciary. Third, empirical research. And fourth, conclusions and recommendations. We will start from the main challenges of Ukraine judiciary. And Ukraine has been undergoing reforms. For example, the process of appointment of judges have been improved with more transparent competition procedures introduced, and there were changes in the professional ethics of candidates. But to ensure that the judiciary enjoys a high level of trust in the eyes of the Ukrainian society, further work is needed. So it is necessary to identify the main problems and base to our concern. First of all, lustration. We talked about it yesterday and we will talk about it now because historically the appointment of judges has been corrupt, creating judicial dynasties. And since 2016, competitive procedures have been introduced for selecting judges involving exams, training, and interviews. The High Anti-Corruption Court, formed in 2018, introduced additional assessments by international experts. However, this is very, very short summary of changes that have been included, and there is still many old-style judges right now out there who still think in a Soviet, post-Soviet types of thinking, and we have to deal with it. So, second, perception of the judiciary is heavily influenced by the court staff, who are often seen as corrupt and dependent on oligarchs and politicians. So training for judges and court staff must focus on integrity and principles rather than just legal procedures, which it is focused right now. Judicial accountability. We can't talk about the trust without this because measures such as recording court hearings, making court decisions public, and requiring judges to submit declarations are in place, but often ineffective. Because judges rarely face consequences for false statements or other types of misconduct. And such behavior does not prevent their promotion, so we have to deal with it. Court efficiency. Right now, the judiciary is hindered by staff shortages, as we discussed in the morning, and heavy workloads. That is leading to delays and lengthy proceedings. This demoralizes judges and degrades the quality of the judicial proceedings, and frequent delays negatively impact those involved in court cases. And those who are involved in court cases. Accessibility. Free legal aid has been expanded beyond criminal cases to assist low-income individuals or just persons who are needed the free legal aid in civil matters. And so it enhances accessibility and fairness in the judicial system. Previously,
free legal aid was limited and of low quality. Right now, people just do not know nothing about it, and we will talk about it later. So about the communication, because they do not know, because of the lack of it, because trust in the judiciary is affected by negative media coverage. Effective communication strategies, including clear explanations of court decisions and proactive public engagement, are needed to improve public perception. Court spokesperson, judge, speakers, and a single judicial press center have been established. Communication training for judiciary representatives has been implemented. However, this type of communication is not what we want, because this type of communication often uses a dry legal language and does not meet public needs. And about the public needs, addressing premises and visitor services is also a very important aspect of this trust, because court facilities often suffer from poor conditions, inadequate access to information, and unsatisfactory visitor services. Long queues, unfriendly staff, and unclear proceedings contribute for negative perceptions. More than a half of lawyers believe that information about the court proceedings and court cases does not meet citizens' needs, including of those of vulnerable groups. So we need to adopt international best practices, because training for future judges should focus on developing their ability to be guided by principles and values rather than merely following legal instructions. So drawing from the experience of more developed countries, this approach aims to foster a judiciary that upholds justice and integrity. Improving performance. We can actually conclude these all types of aspects that I already mentioned in this particular one, because an efficient judicial system ensures timely case consideration, restores justice, and enforces decisions. However, Ukraine faces many challenges, such as the lack of staff and heavy workloads. Trust in the system also depends on effective enforcement of court decisions, which remains a problem despite reforms in the enforcement system. So legal aid is also needed, and combating corruption, a very big problem right now, but it has this complexity, which we will discuss later according to our surveys, because the widespread perception of the judicial corruption influenced by oligarchs and politicians needs to be addressed. Judges should be held accountable for misconduct, and the judiciary should be protected from political pressures to ensure independence. And we can conclude all these aspects into the single one: building public trust. Judiciary should use proactive communication tools, such as press conferences and clear explanation of court's declarations or decisions to build public trust. Changes to procedural codes to ensure decisions are explained clearly can help improve transparency and understanding from the society. So, in order to understand the root of the problem, we need to analyze the experience of the past. It is necessary to understand the attitude of Ukrainian citizens to the judiciary and their assessments of various aspects of the court's activities. And on this topic, there was a very big list, actually, of various surveys. For example, the Razumkov Center Sociological Services, there are 2 services at the request of the Council of Europe office in Ukraine, and the 2021 USA New Justice Program survey on the Ukrainian public trust in the judiciary and other branches of government, and a lot of other surveys. So these particular studies, like in conclusion, in summary, has highlighted a significant influence of the media on shaping the public opinion of the judiciary in Ukraine. The media serves as main and most trusted source of information for most citizens, which often leads to negative perceptions of the courts. Excessive negative coverage, subjective opinions in court decisions, populist criticism of judges, and unfounded accusations contribute to a general lack of trust in a judicial system. However, personal experience, as we can see on this survey, is the court tends to break down these negative stereotypes, with those who have direct interaction expressing more positive assessment. Trust in the justice system remains prevalent, with a majority expressing confidence in district courts and considering court decisions to be lawful and fair. And I work on this because I know we are running out of time. Trust in the courts depends on a fair and timely resolution, the behavior of judges, and support from other branches of government and media. To increase trust in courts, the media should present information about the work of the courts more accurately. It is worth noting that only 1/4 of cases considered by the courts of first instance are appealed. While problematic courts and judges do exist, the judicial system has undergone very much reforms, and in many professional and qualified judges are resulted in it. So proper media coverage can significantly increase public trust, and trust can also be enhanced by aligning the behavior of litigants with that of the judge. Demonstrating respect for the courts and judges, even with disagreeing with their decisions, sends a strong signal to society the trust in courts is being fostered. Also, politicians and officials should exercise caution when evaluating the actions of the court. Only higher court should be responsible for such an court decision, as the actions of the judges should be judged by the High Council of Judges. Any attempts to pressure, influence, or just basically interfere with the actions of the court should be discouraged. Upholding the independence of the judiciary and supporting each judge is crucial in a fair dispute resolution and public trust in a judicial system. That is all for us. Thank you very much.
Okay, so we have still several minutes for discussion, so I open the floor for questions, comments.
But normally the young people first.
Yeah, please come here, and ask questions. Just. So, any questions?
Yeah, here, I have the youngest very funny. It's very short. With regard to Singapore, you mentioned Singapore. I participated in a conference in Singapore, on independence of the judge, courts, justices. And the guy, the representative of Singapore said it's very easy, not speaking of disciplinary measures, but he said, we as a justice at the Supreme Court, we get a salary of 1 million per year. So it's too expensive to corrupt us. So this is, of course, also a solution to the problem. And here, in this context, with regard to Ukraine, I think in 2019, they passed a law that for some of the constitutional justices, they shall be paid with 1,000 euros per month. Has it been implemented, this law? I was really astonished. It's more or less the same salary as the German justices get. It's 12,000, it's a fine salary, I would say. With regard to the ECJ and the possibilities of the judges, the ECJ cannot watch international law. They can just interpret the European legislation, but they cannot push national law. And with regard to the judiciary, they can take measures only insofar as the European regime is affected. As far as are just national cases, it is difficult to interfere. And yeah, one thing with regard to efficiencies was always criticized also by in Ukraine. I'm still waiting for the decision on Maidan. 100 people have been killed up to now. I think only one person has been convicted. Or the trade union house in Odessa. And there was pressure by the European Council, and nothing happened. You know, now it's again year 10 after these events. And no judgment. And this is, I think, is a shame, because it would have been a good occasion also to, in a way, to digest, if I may say so, the event which happened by that time. This by taking such decisions, the courts could found more trust in their activities. The last question, participation of the population. What about the election of judges or justices by the people? As in the United States or in Switzerland? You can make a comment.
Thank you. Yes, please. I just want to take one moment to thank all of the students who have made presentations all day today for the education that you have provided to me. I came here hoping to learn a lot more than I already knew about the justice system. It's good and it's bad in both Ukraine and in Poland. And you did a marvelous job of teaching me. So thank you very, very much. I appreciate it. Yes, please.
One more comment or remark regarding the last panel from trust on the judiciary, and I actually my points about relation between media, trust, and trust to judiciary and the perceived level of corruption. And I want to bring to the table one relevant example, but it was like back in 2020, KNIS or Kyiv Institute for International Institute of Sociology, they conducted a survey, and they put it in a very interesting way. They conducted a survey among people and divided them respondents who actually visited courts, have some cases in the courts, and have some experience in the courts. And second group was people who did not participate and only take information from the media. And the results was very amazing, because a public trust of the judiciary, people who were connected with somehow with the judiciary, was higher. Of course, not 100%, but people who were not engaged with the judiciary, as a public trust, was very low. And also, I want to pay attention, maybe Camille, you know about this consultative council of European justices. They provided opinion on fighting on corruption, and there was also very interesting conclusions about perceived level of corruption and actual level or real level of corruption. And my sense is that your conclusion is very very relevant. That public media should change like narratives approach to covering issues of functioning of the courts from negative to positive. But I want also return to the Professor Moliterno first point yesterday, that NGOs, a lot of media want to earn money, finance from projects, from grants, and they will not receive money when they cover only positive stuff about judiciary. And I think we need in Ukraine and maybe also in Poland that legal community need to stress attention of media, that they need to cover not only negative stuff. Of course, I know that this arrest of Knyaz's case, it was a strong blow to the trust of the judiciary, but still we need somehow to change the general perception, because I believe that perception and the real independence of judiciary is different. Thank you. Would you like to reply?
This one mostly remarks and points, so I'm not sure with the.
Okay, so thanks very much. So
I think
yeah, okay.
I just wanted to reply to the remark about the Court of Justice of the European Union. I didn't want to claim that the Court of Justice can challenge national law. What I said is that in this judgment, the Court of Justice prepared sort of a test that now national courts can use to challenge if some sort of litigation comes from national judges, national courts, only based on European law and not national law. And if this case differs too much to use this test, they can ask another preliminary question. So this was my remark about how judges can preserve their own independence via using the European law.
Okay, thank you. So since we have run out of time about an hour ago, thank you very much for the session, and I've got pleasure and an honor to thanks.
Just very last night, seeing this young generation of lawyers, I will have trust in the future judiciary in Poland and Ukraine. Really.
Thank you very much. I would like to thank the organizers, Monica and Christina, and all participants for 2 days of conference. Thank you very much. Now, I guess I should invite Monica for closing remarks.
Thank you very much. Okay, I should. Okay, so on behalf of Professor Monica Florczyk-Wątor and myself, I would like to say a huge thanks to all students from Poland and from Ukraine for your participation in this project. You've done a really great job. Thank you very much for your research. They are very interesting, and I think that it will be a good motivation and a good experience for your future research. So it's only the beginning. Also, I would like to say, I think actually that you all deserve a round of applause. So thank you very much. Thank you. My special gratitude goes to our brilliant guests from the United States of America, Professor Jim Moliterno, and also Dr. Matthias Hartwig from Germany, from Heidelberg University. Max Planck University, which is situated in Heidelberg, for your engagement, not only yesterday, but also today, for your sharing with us, with your experience, knowledge, and also not only with us, but with students as well. Also, I would like to thank you to our moderators and for everyone who was involved in the realization of this project, and also initially to the Foundation for Polish Science for supporting this project and for inspiring us, because initially we did not plan to engage students in the project, but then we saw that it would be also helpful and it would be a kind of motivation for students as well. And also I would like to say a special thank you for students who came from Kharkiv, from Ukraine, for your, because it was a very long way and it was not simple. So thank you very much. You are very brave. And I hope that this conference will give you another chance and another motivation for your future achievements and for your future research. And also, it was a great pleasure for me. I would like to also excuse for some maybe technical problems. And I also want to notice that this conference was really very dynamic, very interactive, and not boring, as sometimes it could be. So thank you everyone who posed questions, who were engaged in discussion, in active discussion, and who was not only passive listeners, but also participate in active manner. And you were great, so thank you again. And I hope that in future we will continue to, because we only initiate, but you probably everyone noticed that there are many problems, and I think that we should interchange our experience, because we have some positive moments in Ukraine that could be also implemented in Poland. I mean, in case of engagement of NGOs, or the creation of some kind of public integrity council, which will consist of representatives from different NGOs, not only like international experts, but independent subjects, not politicians, who could be involved in the process of appointing judges and in the process of, I would say in general, check and balances system, who could control in somehow the influence and the principle of separation of powers. So and for Ukraine, of course, the main problem is corruption, and we should combat corruption. But I'm sure that with such a brave and intelligent new young generation, I hope that both of our countries, Poland and Ukraine, will succeed. And because we deserve to live with in a world with the rule of law, and I really believe that we will succeed in this process. So thank you very much. I'm also grateful for everyone who works with us online. Yeah, so thank you very much. And
yeah, so maybe very shortly, because I know that you are very tired and probably exhausted. So just I'd like to say three words. The first one is that thank you very much for today, for yesterday, but also for the whole academic year. It was a great pleasure for us to meet you. And also, as I remember our first seminar, which was online, but I was really inspiring and today as well. Secondly, congratulations. I mean, it's really true that the presentations, the speeches were highly interesting and also inspiring. So congratulations. And the third one, we have some diplomas, so we will try to manage this very yeah, quickly. So maybe we will try, maybe we'll close for those who are online. Thank you again for joining us. It will be more difficult from the technical point of view to transmit our celebration.
yeah, so thank you very much, and see you in the future. Goodbye.
Yeah.